Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3233, United States of America versus James Albert Trankle, also known as John Davies, appellant. Mr. Katzoff for the appellant, Mr. Goodhand for the appellate.
Good morning, counsel.
Good morning.
Mr. Katzoff, please proceed when you're ready.
Thank you, Your Honor. Good morning. My name's Howard Katzoff. I represent James Trankle. James Trankle was convicted after a jury trial of one count of conspiracy to commit mail fraud and bank fraud and 5 substantive counts of bank fraud. These raised 3 issues, 3 main general issues, 2 trial issues, and sentencing issues. The issues presented were whether the district court erred in denying his motion for judgment of acquittal or for new trial, whether the district court abused its discretion in excluding evidence offered to show his state of mind.
What's your best issue on appeal?
I think the exclusion of evidence is a good issue and an important issue. And I think the sentencing issue on managerial role and lack of the 0-point offender is a very strong issue.
So what about the argument on the evidentiary point that it was harmless error in view of the other evidence that the government had?
With regard to the exclusion of evidence, the problem, well, let me just start by saying it's a very unusual case. I don't know that I've ever seen a case or a fraud case like this, where the defendant's defense was that he was seeking solicitations for the purpose, for the mission of trying to fight or corrupt professional fundraising practices and to solicit funds and whatnot. But he set up legitimate church 501c3, which was recognized and given an EIN number by the IRS, and thereafter sent out these solicitations. The problem is the government is required to prove specific intent to defraud. And the items that the defendant was trying to introduce, which is a little hard from the record to determine, but they are discussed somewhat: books, pamphlets, magazines, and the like, which tended to expound about the mission to try to fight against corrupt fundraising by professional fundraisers, where most of the money goes to the professional fundraisers and not to the funds. Mr. Trankle
But even if he's trying to set that up, he's setting up accounts that mirror named legitimate and valid agencies, and then the money goes to his accounts, and then he uses it as he deems appropriate. So he's even going against why he set this up in the first place with respect to alleged corruption by the volunteer organizations.
It appears that way on the surface, and certainly that's why I say it's such an unusual case. And
but what is the real state of mind hearsay exception that you're trying to go after in that? What's the state of mind piece to that?
Well, my point is that those pamphlets, magazines, what I think the prosecutor referred to as manifesto, are not being offered for the truth of any of the words in them. It is the fact of the composite of those writings that shows a state of mind consistent with his theory of defense, which was an instruction given by the judge. At the same time, he wasn't able to present that.
So what's the theory of defense to this alleged not having intent to defraud people?
The theory of defense was that he wasn't intending to defraud, that he provided truthful statements in his solicitations. The money went into his accounts, and it was used to create those pamphlets and things that he defined as his mission for those particular charities.
But he also used money for illegitimate.
He did use some money, but it was de minimis, and that was recognized there. I don't have a defense to the de minimis, a few expenditures that were outlined.
Now,
but
would you agree that in presenting this defense, the judge did understand, in other words, I'm going back to that the argument is preserved, that the judge understood that that was the intent of these particular documents to be admitted?
He did. He seemed to actually recognize that they were important.
Okay,
But
he just disagreed and ruled against you. Okay.
Exactly. At one point, he says, I can see where these are relevant to what Mr. Trankle's trying to present. But in the end, he actually picked out like one email and said, and read it, and it was a sort of a hearsay statement. I was fired from my job or something for some reason. But that was one line of the 6 or 8 inches of documentation that was presented to him, and which was described as the pamphlets, magazines, the police crime line, the photos.
So, to the extent the judge understood the purpose for which this evidence was being sought to be admitted and ruled that he thought it was all hearsay, he bought the government's argument. That was the government's argument.
Exactly.
All right. But the judge had not read any of the documents he said he hadn't read them. And he picked out this one email. And as I understood what the judge had in mind was, because he concluded they were all hearsay documents, inadmissible hearsay documents, that basically, if he allowed you to put the documents in evidence in terms of the covers of the booklets, the books, the pamphlets, that would achieve the same purpose that you saw. So why was that error?
Well,
If it was.
I mean, I believe it was error because the covers by themselves don't show the body of work that's not being offered for the truth of the matter, but for Mr. Trankle's state of mind, more so than a non-hearsay argument, really. And the covers themselves don't accomplish that. And without reading them, without looking at them, the judge took the government's word that there's no way to redact them and you should exclude all of them, and excluded all of them.
And so what's your best argument, following up on Judge Charles' questions, as to why this was not harmless error?
Well, if this was really the crux of the defense, and the theory of defense instruction was given, but it was completely undercut by the inability to present the state of mind, for at least to have the jury consider this unusual methodology of having a church and a life mission of trying to combat the corruption, basically, of on a big scale of the professional fundraisers with charities. And that was touched upon in small ways during the trial, but the ability to put that information before the jury was critical, because that's the key element, the specific intent to defraud. Obviously, there can be circumstantial evidence, and the jury got to consider all that, but the government has to prove the intent to defraud, that there was and that there was no legitimate purpose. And where you have—
But doesn't his intent go beyond his narrative that if he's putting all these documents in just to show this is how I intended to go against, any company who, themselves don't use the charitable contributions appropriately, it's kind of his narrative, like he's setting it up. But then you can look at the actions that happen after the fact, which is the bank accounts, how he distributes the funds himself.
Well, the jury would have to evaluate whether it's consistent or inconsistent, but our position is they should have had the opportunity to at least see that that was his genuine intent. That was his genuine state of mind at the
Based on
time.
his own self-serving narrative.
Exactly. Well, the words aren't necessarily a self-serving narrative. They are publications and whatnot that address those issues. No matter who wrote them or what they were a significant part of what was in the sort of church office that was seized. And so that really went to the critical issue of that intent. And where you have the other issues, on its face, the organizations, the DBAs being properly registered and certified, the information being accurate.
And do you have anything else to state about forfeiture? Because you're just suggesting that the court didn't go with the recommendation by probation.
Yeah, I believe that the forfeiture is plain error. The judge assessed a forfeiture amount without requiring any proof from the government and not even accepting what the government asked for in its sentencing memorandum, which I believe was $45,000.
But the judge doesn't have to accept that. The judge can go up. The judge can go down.
Exactly, but it should be based on what proceeds were obtained directly or indirectly by Mr. Trankle. There are obviously a couple of cases that have carved out an exception to that, whereby a leader of a large organization, there can be an inference that they obtain all of the proceeds of activity of illegal activity.
And the forfeiture amount was in the indictment, so it didn't come as a surprise.
No, that was the amount in the indictment. It just wasn't proved by the government, and it wasn't based on the evidence that was introduced. The evidence that was introduced had the co-defendant involved with about 80% of the money, involved the one that opened 4 of the 6 bank accounts that had $120,000 of the money that went in and went out in his name for the most part. That evidence was presented by the government's expert.
They were
And
partners.
well,
How does he escape?
It's hard to say exactly what the roles are. As the judge said, we don't really know a lot about what the other person's role was because he never appeared and there wasn't much to know about him.
He pled guilty.
He pled guilty. We know that. We know he's a co-conspirator, and we know that his name was on a lot of the money. And before a forfeiture amount for monies that weren't obtained directly or indirectly by Mr. Trankle, or before he's subjected to that, there should be more evidence that's required.
And you started out on this when you acknowledged that plain error would be the appropriate standard of review.
I do believe that it was not preserved. The issue that was raised was a different issue, similar to, I believe, the Campos and the Levia or whatever his cases.
Make sure my colleagues don't have additional questions at this point, and we'll give you a little time for rebuttal. Thank you, counsel. We're good, Andrew.
Thank you, Your Honors. May it please the court, David Goodham for the United States. Just briefly touch on the issues raised by my opponent here today. With respect to the exclusion of evidence, I would remiss if I didn't mention that we believe this is a plain error standard review.
Well, let's assume that the judge understood, because he said in his own words, so you want state of mind. And defense counsel said, yes. All right. And so the judge, he made a ruling. All right. So that's what we're looking at. So what I want to be clear about from the government's point of view if a search warrant is executed and at trial, the government calls a law enforcement officer who can testify about the search and what was recovered in the search. Isn't it fairly standard that a defense attorney can ask the custodian or the government witness, what did you recover? And he says, books, articles, etc. And then he can say, would you turn to page 42 of the book that you recovered and read the first paragraph? Happens all the time.
I'm not sure certainly the.
Maybe not all the time, but I'm just saying that often the government does this because it wants to introduce the incriminating nature of what may not be self-evident in what was seized as a result of the search warrant. So where I'm going with this, as you probably know, is the judge said, well, the defendant could testify, but he couldn't ask the government witness about what was seized. And I want to know what the government's position is on that. I'm defense attorney. My client had these books in his office. The hypothetical I gave you of, Officer so-and-so, would you turn to page 45 on the book and read the first paragraph? Nothing wrong with that because the government's putting the proceeds of the search in evidence, isn't it?
I think there is, and I think this boils down to statements of a party opponent. Right. So what defense counsel said to the court when he raised this issue was, these are statements that I made relating to my heroic battle to battle charity fraud. So he could, if he had wanted to take the stand, talk about.
Of course. But he has no obligation to take the stand.
Of course not.
What I'm focusing on is the government is putting evidence in of the proceeds of the search. Is it the government's position that it would be improper, a violation of some rule, were a defense attorney to ask the officer? In
the context of the statements of the defendant, I think yes. I think that the judge, again.
In the context of, is this your gun? Have you ever seen it before? Where did you get it? So what I'm getting at is, why can't he say, is this one of the books that you found in the defendant's office?
He did.
And please turn to page 45 and read the first paragraph.
I don't think that's proper in the context of the materials we're talking about here. That would be him backdooring his own self-serving statements in the government's case. And I think that's the distinction I'm trying to draw about statements of a party opponent versus the defendant. If he wants to take the stand and talk about what he did and what he believed, he could do that because he is not a party opponent.
I understand he can take the stand. All right. But he's not obligated to. And the burden is on the government.
Sure.
But he, as a defendant, has a right to present a defense.
Of course.
And all defenses are self-serving, if you want to put it that way. All right.
Absolutely. But again, I think this is sort of classic scenario of the defendant trying to get his own statements in the government's case.
But this is different. That's what I'm trying to get you to focus on, because I'm not clear in my own mind yet as to why it would be impermissible to do what I've just said, turn to page 45 and read the first paragraph.
Well, again, to my mind, the court permitted the agent and the defense counsel to do what is permissible. If you look at page...
But I'm going further. I'm trying to get the government's position on that matter. As a matter of the defendant's right to present a defense, and the government has introduced evidence against him, can he not ask the government witness about that evidence?
No, the defendant still must adhere to the rules of evidence. And my point is...
What rule of evidence says he can't ask what is on page 45 in the first paragraph?
again, assuming that these books were written by the defendant, which is what he.
Oh, no, counsel. That's the government's theory. Okay, there's no question in the record. Government prosecutor never said, oh, these aren't the defendant's books. These aren't the defendant's articles.
The
Okay.
government described.
My hypothetical.
I understand the government described them as manifestos of the defendant, and that's.
There's a dispute about, I'll withdraw my question.
I'd like to hear the full response though, because I think you're not taking issue with the premise that they are the defendant's documents. I mean,
No.
you're not, I think you're joining issue with Judge Rogers on that.
Absolutely.
But then your further point is?
My further point is that the district court properly recognized what the defendant was trying to do with respect to his own documents. That is, backdoor his own statements in support of what he called a state of mind exception to the hearsay rule. And the court properly concluded, no, you're asking them to be admitted for the truth of the matter asserted, number one. And number two, the court said, I don't see them as state of mind. And that was a proper ruling.
And what's your best case?
My best case is
Improper cross-examination by a defendant in support of his theory of the defense.
well, I would just cite to the federal rules of evidence
They
relating.
don't say anything that the defendant can't ask.
They again, in the context of course, a defendant has a right to put on a defense. But the Supreme Court has made clear that the defendant still has to adhere to the basic rules of evidence. You don't get around those by putting on your defense. And that's
why I say I was going to withdraw my question, because we're just going round and round. I thought the government might give me some insight here as to what the problem was. And I just didn't see it in your brief, and I didn't see it in the cases that were cited.
well, I apologize if I'm not addressing your question. I've endeavored to.
I'm not suggesting bad faith on your
No.
part, but perhaps the U.S. Attorney's Office has not addressed this before and was not prepared to consider this aspect of the district court's ruling, since the argument is, even if there was error, it was harmless.
Certainly, and we've outlined that in our brief that, again, just getting back to my first issue, I think it's important to understand that we're talking about a lot of things that we have no idea what they are. The defendant suggested below, and the government mirrored that when he said these were just the defendant's writings, manifestos. But as I heard my opponent just now admit, as he said, it's a little hard to discern from the record what we're talking about. And that just gets to my Rule 103 point.
That's because they were in evidence. The books were in evidence. The articles were in evidence. That was undisputed before the district court. And the district court said, I have 8 folders in front of me. I haven't read them. All right. So, I mean, that's just undisputed in this case.
It is disputed. That was the whole.
It's disputed.
That these
The judge didn't have 8 folders in front of him.
he had them, but he was being asked to admit them, and
But he had them. They were the proceeds from the search warrant. That was undisputed in the district court.
There's no doubt they were seized as part of the search warrant, and then the defense counsel gave them to the court. And in fact, I would point to appendix page 152, where the defense counsel was allowed to ask the agent about the items that were seized. He did not get into and was not permitted to get into the content, for sure. But when you look at a page 152 of the appendix, you see that we're talking about a lot of materials that were dropped on the district court's bench in the middle of trial. At page 152, you see defense counsel asking the agent about how many books are there, sir? 9 books and some printed paper, and then a little bit down at the bottom of that page. And there are about 8 or 9 folders and some loose papers in there, correct? Yes. So what we're talking about here is a defense counsel who took a library of materials that had been seized, sure enough, been seized by the agents and executing the search warrant, and then he asked to admit them in toto. The district court, I would suggest, properly acted when he said you're asking them to be admitted for the truth of the matter asserted, and I don't believe they satisfy the state of mind exception. That's my only point.
So do you agree that it was preserved in the sense that the judge, even though this is kind of a scant, portion of the transcript, that there was a discussion, the judge knew what they were being
Sure.
for, the state of mind, and then just disagreed?
Sure.
Okay.
But I think that leaps over Federal Rule of Evidence 103. And I don't want to, I'm not going to die on this hill.
Right.
But when you're talking about 9 books and 8 or 9 folders, I think what the rule makers anticipated were scenarios like this, where this court is being asked to review a ruling about substance that it has no idea what it is.
Well, and
where
I'm getting
are
at it
these?
from the standpoint of, are we using a plain error review or not?
I think it's plain error because of the defendant's failure to adhere to Rule 103. That's my only point. If the court disagrees, under any standard of review, we've articulated a harmless error argument. There was abundant evidence, incriminating evidence, but most critically, if you look at the closing argument, at pages 9-10 of my brief, you see that the defendant managed to get this closing argument out to the jury in significant detail.
What do you mean by this argument?
This argument, the defendant, using the photographs of the items seized from his office/home, the argument was, I'm a hero. I was actually working to battle charity fraud, and I was working to expose this. And
So what his state of mind would have.
Exactly. And that's,
The argument is not evidence.
of course not. No, my point is that,
The argument.
sure, it's not evidence, but when you're asking the question of whether this was harmless, you can consider what the party was able to put in front of the jury.
I thought we had to look at what evidence the government had.
That's
Burden of proof.
sure. That's part of the analysis, and as I document at pages 10 to 11 of my brief, there was substantial incriminating evidence going both to his intent to defraud and his numerous false misrepresentations about his actual charities. I see my time's up. I'd be happy to address the forfeiture. I think that under particular this court's case in Leyva, when we are talking about plain error, we are comfortable with the notion, this court is comfortable with the notion that when a defendant has been labeled a leader, there may and has directly supervised the proceeds, then the forfeiture, he can be held accountable for the entire amount of those proceeds. And the exact quote from Campos is, in Leyva, the court affirmed attribution to the leader of an organization of the proceedings from activities directly supervised by him in a conspiracy. That's what we have here. So my core point is, in the conceded plain error world that we are living in here, I think Leyva and Campos stand for the proposition that this court can affirm.
I'm sure my colleagues don't have additional questions for you.
We would ask you to affirm the judgment below. Thank you.
Thank you, counsel. Mr. Katzoff, we'll give you 2 minutes for a rebuttal.
It's not rebuttal, but I did not get to address this sentencing or managerial role, which sort of related a bit to the forfeiture. And
Well, it's 2 minutes for you to use how you wish to use it.
although I hope it's a mood issue, but I do want to address it. This is a case where particularly we've challenged a number of sentencing enhancements, but the managerial role one is the one, and I think the court actually conceded is perhaps the most difficult of the ones he had to address from the recommendations of the pre-sentence report. And it results in a 2-level increase and denial of a 2-level decrease under 4C 1.1 for 0-point offenders. So it's a pretty significant enhancement because it has a 4-level impact. And the case law is pretty clear that all persons receiving an enhancement under 3B 1.1 must exercise some control over others. And the findings, even by a preponderance, were, according to the court, were just scant in terms of addressing the roles. The court conceded it didn't really know much about Mr. Seibert's role.
What did he actually plead guilty to?
He pled guilty to
Beyond the charge, like
I
did
believe it was conspiracy to commit mail
he,
fraud.
in terms of the factual recitation, was that part of the government's piece to give him some type of leadership role?
You know, I have to say that I would have to provide that to the court.
Because I would assume they did.
I didn't focus on that. I focused on the evidence that was presented, and that evidence showed two participants. Mr. Seibert largely involved, I believe Judge Rogers said partner, might be a fair assessment, although we don't even know that. We don't know the fact that Mr. Trankle was at the church office residence, whether that's significant. Mr. Seibert may have been living in a mansion 2 houses down and having him with his bicycle, his microwave, his air mattress, staying at the church. We just know nothing about his profits. There's no evidence of wealth. The financial information about the deposits and that was introduced through the government shows him heavily involved in all of that. And so I would submit that the managerial role is in error, and the denial of the 4C 1.10 point that because of the 4-level difference in that error, at a minimum, the case should be remanded for resentencing. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. Katzoff, you are appointed by the court to represent the appellant in this matter,
Yes,
and the court thanks you for your assistance.
Welcome.
Case number 24-5239. In re application of the United States for an order pursuant to 18 U.S.C. 2705B, empower oversight whistleblowers and research appellants for the United States of America. Mr. Field for the appellants, Mr. Hansford for the appellant.
Good morning, counsel. Mr. Field, please proceed when you're ready.
May it please the court, Brian Field on behalf of the appellant, Empower Oversight Whistleblowers and Research. I'd like to reserve 2 minutes for rebuttal. Your Honors, there are 2 reasons that the district court's decision here should be reversed, and I'll address both in turn. First, because there is sufficient information in the public domain, reversal is appropriate under any legal standard. And second, the district court erred in reviewing Empower Oversight's request under Rule 6E. On this first point, I'd like to begin where much of the briefing ended. This court should reverse the district court, and in doing so, it need not determine or resolve the question of whether NDO applications are subject to Rule 6E, the common law, or the First Amendment. Release under any standard is appropriate because the information is sufficiently public. In the OIG report that
So
we
you don't think that we need to resolve whether or not it's a judicial record or an ancillary proceeding with respect to the grand jury proceedings?
I think under any standard, release is appropriate here, so the court need not. Now, I would say the court can and should conclude that these records are not 6E records, but because the information—
But there generally is not a common law right of access to something that's attendant to a grand jury proceeding because that's secret. So wouldn't we have to make a determination one way or the other?
Well, if we're proceeding down the Rule 6E route, 6E yields when the information is publicly disclosed or is in the public domain. If we're proceeding down the common law route, the public release and discussion of information weighs in favor of release under the Hubbard factors. So all I'm submitting is that there is a way to decide this case short of resolving which path we should be going down.
The district court actually had an in-camera proceeding and determined that certain documents could be released, but then some redacted and some not released.
That's correct, Your Honor. The district court reviewed the NDO applications in camera and concluded that certain information could be released and that certain information needed to be redacted. We don't think, based on the public record through the OIG report, that that decision was correct. We think that the redacted material should be released. And the reason we think that, there's really four things we know from the OIG report that point persuasively in favor of additional release being necessary. First and foremost, we see that the OIG report quotes from NDO applications at pages 41 to 42 of the OIG report. If DOJ is correct and NDO applications are protected Rule 6E materials, DOJ is necessarily arguing that OIG violated Rule 6E. That, of course, can't be the case. In fact, in DOJ's brief at page 35, they say the OIG report did not disclose Rule 6E materials. But how can that be the case? We have an OIG report that is quoting the explanatory portions of an NDO application. That's precisely what Empower Oversight is asking for, and that's precisely what DOJ is saying Empower Oversight cannot have. But somehow DOJ's Office of the Inspector General is able to discuss and
But that
quote.
report was not before the district court.
Your Honor, it was not before the district court.
And I'm just asking that, what do we do about that? Is there a remand necessary just for the district court to then look at that report and then look at what its ruling was against that report?
So In re Cheney is instructive here. So In re Cheney says that the fact that this information came out after a district court's decision is not dispositive. The court can still consider it. To be sure, In re Cheney remanded the case. We don't actually think that's necessary here for a few reasons. First and foremost is the parties have met issue here quite a bit on the OIG report. We fully briefed it in this case. Both sides have had occasion to discuss it. We also addressed the public disclosure point in the district court. So district court has had an opportunity to see both sides' view of what is the relevance of public disclosure and how is that relevant to the Rule 6E analysis in the DOJ's view and our view under Hubbard. Because of those, we think that remand's not necessary. And I would also point out that In re Cheney had a really different fact pattern. In that case, it was just a reference from the Office of the Special Counsel stating that there were some immunity questions raised. Politico in that case requested remand, and there was an open question as to how much that public statement actually changes the dispute here. Our case, I think, is quite different. You have a 90-page OIG report that gets into detail about this investigation, gets into detail about the NDO applications, and we've had occasion to brief them. So there isn't an open question as to how it changes the dynamic.
So
I think it changes it fundamentally.
With the OIG report, so a couple things. There's no dispute that the particular NDO applications in this case, under the unredacted NDO applications in this case, are not made public. They're not already public somewhere.
The NDO applications that we are seeking are public only after the district court's decision.
Right.
And only
As
two
redacted.
of them of multiple and only as redacted.
Right. And then with the OIG reports, do we know from the OIG report itself that it points to a particular NDO application?
We know, so at pages 41 to 42, the OIG report quotes an example of the boilerplate explanation. So I'm sure Your Honor.
But it's just a boilerplate example. So the OIG report itself doesn't make public that it relates to a particular NDO application, like by, with a case number or something like that. That's not that kind of connection.
That's correct, Your Honor. And I would have 2 points to respond. One is I think we need to step back for a moment and really keep in mind what DOJ's position is here. DOJ is not saying this particular NDO application is unique and is subject to Rule 6E and has grand jury information in it. They're also not saying that portions of it are subject to Rule 6E. They're saying NDO applications at large are Rule 6E materials, therefore they have to stay protected. So Your Honor's question, yes, it is presumably a different NDO application. We actually don't know. Right. But if we stipulate that it's a different NDO application, that still raises the question of how can OIG be quoting an NDO application if it's supposed to be private? But on your more specific.
I thought there were two different things going on. I thought that and obviously we'll hear from the government, but I thought there's a general argument about NDO applications vis-a-vis Rule 6E. And that may well be, as a general matter, NDO applications that are submitted to a grand jury before a grand jury, in connection with the grand jury,
Certainly.
are generally protected grand jury materials for purposes of Rule 6C. And then there's the question of, okay, whatever you might think about that, here, there's some stuff that's already been made public. And then the question becomes, with respect to the stuff that's already been made public, does that mean that there's no need any longer to redact this NDO application in particular?
But Your Honor, we would certainly agree with that second point, that there is no, given the public disclosure, there's no need to continue the redaction. I would point to the.
But I thought the relevant point there is that, well, if the material that's already been made public, i.e. the OIG report, doesn't point to a specific NDO application and let the public know which specific NDO application it relates to, then whatever might be true about a boilerplate NDO application being out there because of the OIG report doesn't point to any specific NDO application, including the one that's before us now. So that part of it hasn't been made public.
2 points, Your Honor. First, I just wanted to close the loop on what I was suggesting earlier, which is DOJ's position at pages 7, 14, and 18 of its brief point to NDO applications being subject to Rule 6E. Things, at page 14, they say Rule 6E directly covers NDO applications. So I don't think DOJ's parsing it quite this way, and certainly DOJ's counsel can suggest otherwise. But I do want to say it is true that the OIG report doesn't quote Mr. Foster's NDO application. But we also can step back and look at facts and context clues and say, we're talking about the same thing here. We have, now to be sure, DOJ hasn't actually said we're not talking about the same thing. They've said Empower Oversight hasn't proven that we are. And I would invite the court to ask counsel what DOJ's position is on this. But the dates line up, the facts line up, and common sense shows that we're talking about the same thing. Mr. Foster was oversight counsel for the Senate. This investigation involved members of the Senate Oversight Committee who were performing oversight of DOJ, having their records subpoenaed. We know the subpoena was issued in September 2017 in the OIG report, so too for Mr. Foster's. We know the NDO applications were September 2017 through August 2021, so too for the ones involving Mr. Foster. I think that these facts put together show a common sense conclusion that we're talking about the same thing. And then we're talking about them in depth. We're talking that they are boilerplate. When we look at the NDO application that's redacted, it's a very short explanatory section at paragraphs, I think, 8 through 10, that really seems to show that there's a boilerplate explanation. There's no discussion of risks and so forth that would be required under 2705B.
I am curious about what you would say is the distinction here with respect to whether this should be classified as a judicial record or an ancillary proceeding, because by your statement of suggesting that the government believes all NDO applications are subject to 6E, wouldn't there be a different analysis as to whether or not it's a judicial record or it's an ancillary grand jury proceeding?
Stepping back, I don't know that that's the threshold question, Your Honor. I think judicial records, so if we go to how this court addressed these questions in Leopold II, judicial record was a starting point. Judicial records can still be subject to 6E. It can be a judicial record. Common law applies as the default unless Congress has spoken to it. So I think that would be the mode of analysis, Your Honor. I don't see how one could argue that these are not judicial records. These are applications that were filed in order to receive a court order. That seems to be in the heartland of a judicial record.
And the district court kind of skipped over that, just made a little simple sentence about judicial record and then went right into ancillary record.
That's correct. So I think that the way that I would frame this is the first question is judicial record, and Leopold II follows this same track. Judicial record is the first question. Common law applies as default as the second question. Has Congress spoken directly to it? That's where there's the 6E route, if Congress has spoken to it. Our position is that Congress hasn't spoken to it because this doesn't fall within the universe of ancillary grand jury records that we see in the Dow Jones case is the best example from this court. It really sets out what's an ancillary grand jury record. They're talking about things that disclose identities of witness, transcripts of hearings, and the like. An NDO application, if you look at 2705B, they don't have to talk about the grand jury's investigation at all in order to justify an NDO application. You could talk about a flight risk. You could talk about any number of different things.
How do we know that what you're seeking doesn't do exactly that?
Well, that it doesn't disclose this information?
That it doesn't disclose names, identities, particular things that the grand jury is looking at.
No, we are admittedly fighting with one arm tied behind our back because we're
Yes,
fighting
but the way
against a
you're
sealed
presenting the
addendum.
argument
But-
is it's a slam dunk. And I think you're skipping over some of the matters or facts or evidentiary arguments that are presented to the court. And so I think you have to address those if you're to prevail.
Be happy to, Your Honor. So I think a few points. One is I do think that with the OIG report, it strains a bit of logic to think that there is any information in the NDO applications that would reveal the inner workings of the grand jury, as this court explained in LeBeau, in Chief Judge Srinivasan's decision, or in the Commonwealth of Puerto Rico case, that there's information that's going to reveal some aspect of the grand jury's investigation. Those are the standards. And from the OIG report and from the briefing, because that's in a public briefing, that's not the point that DOJ has made. DOJ has stood back and made this point more generally that NDO applications are 6E materials. If DOJ wants to make the argument that there's specific grand jury material scattered throughout the application, that's a different argument. And in fact, Chief Judge Boasberg addressed a similar argument in the New York Times case that we cited. And Chief Judge Boasberg there addressed the 6E question under parts 4 and 5 of the Hubbard factors, privacy and prejudice.
It's a different factual matter. That's not the case we have here.
But
Okay. I know you want to get to Hubbard, but what the government says is you don't get to Hubbard. All right. And you are setting up some threshold that you can see the judicial records. You can see, at least as I understand it, generally these matters may be under investigation by the grand jury. But as I hear your argument today, because the OIG report, as you discussed with the chief judge, talks about, for example, here's what these orders say, that the whole analysis changes and we're back to Hubbard. And I think that's a leap I'm having trouble following.
I don't think we even need to make that leap because I do think that
Well, if you're bound by 6E and they're ancillary, you do have to make some sort of jump to get out of 6E.
Where I was going was I don't think we're in 6E land to begin with. And that's why I see a substantial difference between an NDO application and like a motion to quash. A motion to quash, you're going to have to discuss the specifics of a grand jury's investigation.
Nothing to say that what Judge Boasberg had before him and he examined in him doesn't do exactly what you say needs to be done.
I do think, again, the fact that we're now almost a decade on from the investigation.
Well, that's another issue. That's a Hubbard issue. Okay. But we're not at Hubbard.
That's not a Hubbard. Your Honor, respectfully,
It's
that's a
one of the
6E.
factors.
But that's a 6E question. 6E yields. This court has said that 6E yields when information becomes public. So it's precisely within the scope of 6E.
Counsel, you know what I'm saying. I just don't understand your argument because you have conceded, I thought, in response to the chief judge's question, that you have no information about specific do not disclose your orders, that doesn't appear in the OIG report.
We conceded that we do not know. Let me say it differently. We concede that the OIG report does not make express reference to Mr. Foster in the NDO applications here. That being said,
Or anyone else specifically in that sense, where the chief judge refused to release.
We do know that the NDO applications that were filed in this investigation about the seeking of communications records from members of Congress and staff. We know that it's from one of those investigations, or it's related to one of those subpoenas. They don't specifically quote Mr. Foster's, but this wasn't an OIG report saying, oh, and by the way, there was this other NDO application somewhere else, and this is what it said. It is from this investigation, but admittedly, we know it's not.
The theory is that once you know, for example, that there's an investigation of a committee and the staff to the committee that there is no basis for keeping the NGO secret.
I don't think our proposed rule is quite that narrow. I think we know.
I thought that was pretty broad.
I think that I think the context clues again point to this being from the same investigation. If this court were to remand it, we would put in evidence that this is the same investigation. That's obviously not in the record below because the OIG report came out later, but that is absolutely information that on remand we can put in the record and have the court look at our evidence that this is the exact same NDO application. But I don't think that necessarily that's a question that even needs to be answered because I still think under this court's Dow Jones decision, an NDO application at large cannot be seen as an ancillary grand jury record. I don't think
Ever is your
at the whole, I don't think that analysis carries.
It's a categorical approach.
There can be NDO applications that discuss grand jury information. Parts 4 and 5 of Hubbard, I'll give the court an opportunity to assess that question. That's where Chief Judge Boasberg addressed it in a different case. That's where he should have addressed it here. There's no other questions.
Questions at this time? We'll give you a little time for rebuttal.
Appreciate it.
Mr. Hansford.
Good morning, and may it please the court, Eric Hansford for the United States. The district court properly found that this case presents a straightforward application of Rule 6E, which prohibits disclosure of any matter that is occurring before a grand jury. And I think I'll start where the argument ended, which is whether or not the NDO application that relates to a grand jury subpoena would normally be treated as Rule 6E material. I think this is it is reflected in Rule 66, but it's most straightforward in Local Rule 6.1, which we quote in the brief at page 17. That specifically says that an application filed in connection with a grand jury subpoena shall be filed under seal. And it can be unsealed if the district court finds that it is not necessary, that sealing is not necessary to prevent disclosure of matters occurring before the grand jury. So I think what that straightforwardly says is you start out with this being treated under seal as Rule 6E material. It should be unsealed insofar as it doesn't disclose, as you can unseal without disclosing matters occurring before the grand jury. That's precisely the inquiry that the district court engaged in this case.
And does the distinction between judicial record and whether it's ancillary matter to how you are saying that next step is with respect to 6?
No, I don't think so. I think the judicial record discussion here is just a red herring. I think that what we have is that Rule 6E and Local Rule 6.1 says that these sorts of records are to be sealed insofar as their unsealing would disclose a matter occurring before the grand jury. So that is the question, is whether.
For your purposes, it doesn't matter if they're judicial records.
Correct.
You're fine if they're judicial records, because I think even the other side, as I understand the argument from this morning and from the briefing, agrees that even if they're judicial records, you still have to ask the question whether they fall within the compass of Rule 6E.
I think that's right. And it doesn't even really make sense to ask the judicial record question at the threshold, because really the threshold question is this Rule 6E material? That's
and if it is, it can't be disclosed.
Correct.
Unless
Right.
it's a public.
Exactly. And that's how, Dow Jones, which I think is maybe the most thorough discussion of this, that's how it approaches this and just says it's Rule 6E material. We don't need to get into unsealing. And so then turning to the OIG report here, I think our threshold argument is that this court should not be considering factual developments that postdate the district court's decision. And instead, we would just follow the normal appellate rule that we decide matters based on the record that is before the district court at the time of the district court's
decision. That unpublished opinion by our court, though, in Ray Cheney.
So Cheney is unpublished. Cheney does take a contrary approach. We agree with that. It's unpublished. We don't find the reasoning of that terribly persuasive. It's relying heavily on this 1989 sealed case. But the 1989 Seal case makes a passing reference to how in a prior appeal, they had decided to remand at the request of the government, which had prevailed in the original case. It is not a holding of Seal case. It's kind of a one sentence background discussion. And I think there are lots of institutional reasons that we want this rule, that you decide the record based on you decide the appeal based on the record before the district.
But if there has been a later publication, why wouldn't that matter?
Say that one more time.
If there has been a later publication of the information, why wouldn't that matter? Like if we're deciding something that goes against what's already out in the public universe, why wouldn't it matter that there's been a post-dated record?
So I think our position is that you could file a new unsealing application. That unsealing is often an iterative process. That is how it is supposed to work, but that it wouldn't justify a remand in this case. And I think
What would be the practical difference? So if there was a new motion filed, I mean, it's not like there's a res judicata problem with filing a new motion or something.
It's not a res judicata issue. I do think it tells you about the default. So if you remand, then the default is more litigation on this issue. Instead, this court says affirmed, the district court properly made its decision on the record before it. If you want to file a new unsealing application, you could do so. Then the default becomes the defendant or the appellant has to seek unsealing anew, has to make that decision anew. And I think it's relevant. You can see the relevance in this case, where I think a lot of their arguments relate to the broader principles that are discussed in the OIG report, even though we don't think the OIG report acts as a public disclosure as to the specifics here. I think they're broader themes of kind of how it is that DOJ was handling congressional subpoenas. Those are reflected in the OIG report. And so I'm not sure that further litigation really would necessarily occur, that the expense of further litigation would make sense in this case, just for appellants to make their point further. I think it's possible the OIG report already makes that point for them. But I think just institutionally, it is better for the government, it's better for the court, it's better for all parties to have the record be determined by the district court, as opposed to trying to introduce new evidence on appeal that would alter the record.
Okay, so if you say that it doesn't matter if it's a judicial record or an ancillary record and you jump straight to 6E, you're suggesting that 6E supplants the common law right of access?
Yes, and I think Dow Jones has already said that, has already held that. I think the 2000 sealed case says that.
And do you think that the district court sufficiently analyzed exactly what we're talking about here in terms of this supplanting?
Yes, and I think the district court's approach, which is consistent with what the government's arguing here, is that we don't need to get into these judicial record questions because really everything's going to rise and fall on Rule 6E. And I think I take that to be the approach that the district court made here. We do want to say, as to the OIG report, in line with Judge Srinivasan's questions, the OIG report does not specifically identify the grand jury subpoena allegedly at issue here or any other specific grand jury subpoenas as being discussed in the OIG report. It says that we are redacting Rule 6E material or not including Rule 6E material. We are not making disclosures of a matter occurring before the grand jury. And so I think this is also on different footing from Cheney, where in Cheney, the district court's opinion was based on the premise that it had not been disclosed that there was this executive privilege litigation going on. So nothing about it could be disclosed. And then by the time of appeal, that had been disclosed in a public filing by the government. So everyone agreed that did change the analysis. Here, there is strong disagreement on that.
And I want to make sure also that we don't have a broad rule that all NDO, are you taking a position that all NDO applications would contain some type of secret information?
No, and I mean, I think that, so it would have to be in connection with a grand jury subpoena. And under the Rule 6E principles and the 6.1 principles, it is only sealed insofar as it discusses a matter that is occurring before the grand jury. So that is the part that is sealed, is if it discusses a matter that is occurring before the grand jury, then it's sealed. And that's
If it's an NDO application related to a grand jury, then it seems like, I'm not suggesting this is necessarily a problem for you, but it seems like, looking at the text of Rule 6E, just so I have it right, seems pretty darn likely that it's going to involve disclosure of a matter occurring before a grand jury if the NDO application were unveiled.
Yes, I think that's correct. And I think we, you know, in our public portion of the brief, we explain why that is generally going to be correct on pages 21 to 22. But that is where the sealing comes from, is because it is discussing a matter occurring before a grand jury, which is just always going to be sealed material. It's not something special about the
Which is,
NDO
I mean, the text of the rule
applications.
already talks about the subpoenas that are often tied up with an NDO application.
Correct, exactly.
So we
Right.
know that it sweeps to cover all subpoenas related to grand juries, and an NDO application could be seen as an adjunct to
Correct.
a subpoena. To some
Right. And Lopez also says that is going to cover grand jury subpoenas, that those are going to fall under this.
I have a, oh, go ahead.
Go ahead. Continue your line.
It was going to switch a little bit, but I want to
Okay,
make sure.
just in Ray North, because there was a remand there, I believe.
Yes, there was a remand in that case, though it was, I'm sorry, I'm forgetting the ground for the remand at this point, but it was specific as to the, well, I guess in Ray North, they disclose much of the independent counsel report for the most part.
The report disclosed much of what had been previously disclosed.
So In Re North is about the independent counsel report that is related to the Iran-Contra scandal. And I think, I guess, and I think what the court says is, in that case, there has been such public disclosures that we think the cat is out of the bag. That may be the origination of the cat is out of the bag line. And so therefore, we are going to disclose the independent counsel report. I guess I'm
How's that
not.
unlike the OIG report here?
So the OIG report does not disclose Rule 6E material, whereas the independent counsel report, or the discussions of it, the interim reports had disclosed the Rule 6E material. So that had been disclosed as Rule 6E material already. The OIG report does not disclose that. I guess I'm not remembering if there actually was I'm not sure there was a remand in North. I think the court actually
Well,
just.
I didn't mean remand. They allowed the review of the report.
That's correct. And they found, and I think North is an unusual case where they say kind of, we can't do redactions. We have to, it has to be all disclosed or all undisclosed, but they recognize this is all falling under Rule 6E. And then they say, all of this is already out in the public domain. And therefore we are going to.
The distinction for you is in North, what was out in the public domain already is different from
Right.
what is ostensibly out in the public domain now as a result of the OIG report.
Exactly. That's
So
correct.
on that question, so I know you've got your threshold point that we shouldn't be talking about the OIG report at all because it comes about after
Right.
the record that the district court was looking at.
Yes.
So just put that aside for
Sure.
1 second and assume that we're going to look at it.
Yep.
Or at least that we can. Then on that, if we do, it sounds like you're focused on the point that the OIG report actually doesn't itself disclose 6E materials. And with respect to the NDO application that's before us here, it doesn't on its face tie anything to a particular NDO application.
Right. So the OIG report does not say that it is discussing the NDO application. That's at issue in this case.
Right. And
That-
so if that were the important criterion, and it could be, if that were the important criterion, I guess the question is, what the other side says is, look, just as a matter of context, you kind of look at the calendars, you align things up, and it almost seems like it kind of has to be. And so that
Sure.
You heard that statement, and I'm just putting that, giving you an opportunity to respond to.
Sure. So I would say first, they've said that in the abstract, but kind of not said that with specifics. They have not pointed to here, line by line, here in the OIG report, here's what we have. This lines up with this specific subpoena. So they've kind of made this kind of general argument, but have not made the specifics argument that I think you would need to have public disclosure. But I think you can look at the Dow Jones case where there's reporters, that's about the Clinton grand jury investigation. There's reporters camped out outside the courthouse. Reporters are reporting on who's going into the courthouse, who's not. They're kind of trying to put together what's going on in the grand jury investigation. And this court says that is not cat out of the bag. That's not kind of putting together the pieces like that. That's not going to work for a grand jury disclosure. And instead, I think In re Cheney does have a good summary of this, is what you need is the witness to actually say, here's what I testified in the grand jury. You need the attorney for the witness to say that, or you need the government to have a public filing that says, here's what was discussed in the grand jury.
So in other words, from your perspective, from the government's perspective, even if you could look at the context and make an educated assessment of what might very likely be an issue, that's still not enough for purposes of a cat out of the bag idea.
That's correct. And I think that's also consistent with what this court says in North, which is that, even if you have kind of leaks that are happening, even if you have reporting on what's likely happening, the government's obligation is nonetheless to stand silent in that instance, is not to provide confirmation of that and not to use the fact that leaks are out to say that Rule 6E has disappeared. If there are no further questions,
Don't have additional questions at this point.
we'd ask this court to affirm.
Thank you, counsel. Mr. Field, we'll give you the 2 minutes you asked for rebuttal.
Thank you, Your Honor. Just a few points. I would like to note, counsel raised a question about whether or not we have really tied things together from the OIG report and the record here. Just at a very high level, we have at page 42 from the OIG report to the date of the subpoena. We have the subpoena in the record at appendix pages 45 and 47. We have the applications discussed in the OIG report. I'm sorry, we have details about the investigation at pages 27 to 28 of the OIG report, which line up with the facts we've discussed in the briefing below. We have the OIG report at page 42 talking about the last NDO, which lines up precisely with the dates of the NDO application. The NDO at appendix pages 42 to 43. And we also know from the fact that the NDOs have been allowed to expire, that the underlying grand jury investigation is complete. That that Google was allowed to inform Mr. Foster, which Douglas Oil decision of the Supreme Court says that weighs in favor of release, even if we're operating under 6E. Want to also make sure to emphasize that to my discussion with Judge Rogers, if there is identity information, we've said all along, identity information is clearly something that could still be redacted. There's discussion of local rule 6.1. I think 6.1, I think that's a bit of a red herring, because this court said in the 2000 In re Seal case, that is just that's just another, basically another definition of an ancillary grand jury record. 6.1 is not a different rule. It's just discussing ancillary grand jury records. In re North is really important, because in re North, the court focused on the partial release of information and said the partialness of the release weighs in favor of full release, because when you have partial information out there, you have partial conclusions being reached by the public. So the partialness of the release of information here with the OIG report actually weighs in favor of full release under in re North. It sounded to me like DOJ counsel agreed that the explanatory language from an NDO application can be released, because that is, after all, an OIG report. As counsel stated, that's not grand jury information. So we would, suggest that the same is the case here. And the last point I want to make, Your Honor, is you said that it's likely that any NDO application related to a grand jury subpoena is going to address grand jury information. I think if you look at the 5 subparts of 2705B, you'll see that any one of those could be addressed without discussing any aspect of a grand jury investigation, a flight risk or something like that discussed. So it's not necessarily the case that any NDO application tied to a subpoena is going to discuss a grand jury investigation. And with that, we would request that this court reverse the district court.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 24-1259 et al. Office of the Commissioner of Baseball et al. Appellants versus Librarian of Congress et al. Ms. Theodore for appellants, Office of the Commissioner of Baseball et al. Mr. Dove for appellant Public Broadcasting Service. Ms. Carson for the appellees. Mr. McLean for the interveners.
Morning, council. Ms.
Morning.
Theodore, please proceed when you're ready.
Good morning, Elizabeth Theodore on behalf of the joint sports claimants. I'd like to save 5 minutes for rebuttal if possible. The board's allocation decision must be vacated for 3 independent reasons. First, the board relied on an arbitrary regression that produced absurd results. Second, the board applied an arbitrary adjustment to the survey that it admitted lacked any rationale. And third, the board synthesized the regression in the survey in an arbitrary way, resulting in an allocation for sports in 2014 that inexplicably fell below sports' share under either method the board purported to be crediting. So let me start with the regression, which absurdly concluded that live sports games that cable systems pay tens of millions of dollars to air on the open market were the least valuable content category. The regression was so imprecise that the board had to resort to the 55% confidence level. And even then, it couldn't exclude the possibility that sports has a negative value. This is at JA 511, that airing live NFL games reduces the value of your channel to cable systems. And that's just totally outside the range of acceptable scientific evidence. When this court approved reliance on a regression previously in the 2020 program suppliers decision, it said it was non-arbitrary because the regression produced narrow confidence intervals at 95% confidence. Here at 95% confidence, the regression can't tell you whether commercial television should get 6% or 20% in 2016, also at JA 511. And that commercial television, that's one of the categories that the board says that the regression does accurately measure. The board itself found that the regression could not accurately measure half of the claimant groups, so that's sports, Canadian, and devotional, which amount to between 35% and 42.9% of the royalty pool. And
So this issue was presented to the board on rehearing.
So there were certain issues presented to the board on rehearing relating to the acceptance of the Tyler above minimum fee regression, which was a regression that nobody had proposed. But I think the board did not respond to any of these absurdities, and notably neither has the government in its brief.
And what I'm getting at is motions for reconsideration were filed, and granted. And there was briefing, and the board made decisions and indicated, A, you don't get a second bite at the apple, but B, said that you have to show clear error or manifest injustice, all right, for it to take up an issue. So what's your response to what the board did in that context? Because before us is both the original decision and the decision on rehearing.
I don't think that the standard the board applied on reconsideration with respect to sort of clear error has anything to do with the standard, the normal APA substantial evidence arbitrary capricious standard that this court is going to apply.
No, I don't disagree with you. But what the board said, and that's what I'm trying to clarify here, the board said your burden, claimant's burden in seeking rehearing is to demonstrate clear error or manifest injustice. And so in some instances, the board said the parties haven't presented such evidence. But they said, we'll go ahead and discuss the merits of the argument that's being made. And so it goes on. And so while we're on an APA standard of review of the board's decisions, we have to take into account what it said in response to the arguments that were made in connection with rehearing, correct?
I think any substantive points it made, certainly, but I don't think it had any substantive responses to the things I'm saying. I don't think that the sort of.
So these issues are being raised before us for the first time, or you're saying you raised them, but they were never addressed on rehearing?
So I'm saying we raised many of these issues at the actual original board determination level. I think a lot of what the board was saying about second bite at the apple is basically like, look, you already raised these, we addressed these, we're not going to address them again.
Unless you can show clear error or manifest injustice.
Yes, Your Honor, but I think it's.
All I'm trying to get at is you quoted, all sides have quoted what our court has said about our review under an APA standard of these types of board allocations. We're talking about rough justice, all right? So I'm trying to understand what it is that we should be looking at in terms of the board says, we've read your motion for reconsideration. There's nothing new here. There's nothing that shows clear error or manifest injustice. So where the court has an APA standard of review, but we're looking for rough justice, we're not looking for precision. How do we put all that together?
I think that what the court has said is that you have to have a non-arbitrary method of allocation. And I think what the method the board chose is arbitrary. And I don't think that the sort of rehearing standard is really relevant here in the same way that, you know, this court might deny en banc review or panel rehearing because there's nothing new, and that wouldn't affect how the Supreme Court reviews the underlying decision.
So is the underlying argument here that the board, in adopting the methodology it did, inadequately explain why it chose particular allocation numbers for the various claimants?
That is one of our many, that is our, I think, our third argument.
I'm just trying to get this under my belt, so to speak, in terms of when you say, well, they were arbitrary, they did this, they that. Had the board explained why it chose those numbers, we might be in a different position in addressing your arguments. That's what I'm trying to understand.
Yeah, I think had the board done a better job of responding to some of our arguments, you would be in a different, better position. But I think what the board has to have is it has to have a non-arbitrary method that's supported by substantial evidence that suggests that the numbers it's choosing from are correct, that they actually reflect marketplace value. And
so the board says all the parties have proposed various methodologies. We've looked at them all, and we've made some decisions and determinations about the methodologies. And while we like Tyler best, there's some problems there. And while we like the survey, there are problems there. And everybody agrees that what period of time the board is addressing is different from the past. So the board says, you know, the normal procedure isn't going to work. And I don't hear arguments being made other than to say, well, the board should have addressed our position as distinct from what the board has done.
well, I'd be happy to just sort of very specifically address why what the board did was arbitrary, which I think we'll get at your question. So with respect to the regression, So the board said, we think 90% of the relevant data is completely irrelevant and can't be included in the regression because it's based on people who are not making economic decisions. And then what it says is we're going to accept a regression that throws out 90% of the data. Nobody proposed that regression. Nobody. Dr. Tyler did not propose that regression. He did not suggest it should be used. And then what that regression does is it produces totally absurd results. And even which the board acknowledged for many claimant categories. And Dr. Tyler himself said, and this is at JA 343, if a regression is wrong for one coefficient, all of the other coefficients are likely to be biased as well in unknown directions. He said himself, Dr. Tyler said himself, that a badly measured variable contaminates all of the estimates. And the board finds that many of these variables are wrong, are badly measured. The regression reports that the infomercials are entitled to 7.3% of the royalties, even though everyone agrees they have no marketplace value.
So can I, on this, so
Yeah.
didn't Tyler say about the sensitivity, as his sensitivity model as opposed to the baseline model, the sensitivity model, which only looks at the above minimum fee ones. So I thought he said, considering a version of the model, including only above minimum fee CSOs does have some merit.
He did. He said some merit. He did.
Right.
Yes.
So it's not, I mean, by his own estimation, it's not outlandish to look at this. He says it has some merit. And then he goes on to explain why it has some merit, because that's going to be the best in indication of a revealed preference. Now, it still may be, I mean, you may still have some problems with it, but based on Tyler's own assessment, he's not warding people off from looking at that. He's saying, yeah, that could have some merit. And because it, maps onto revealed preferences in a way that's more telling.
He says that it has some merit sort of to corroborate the original survey that the board, original regression that the board finds is wrong. But he says it's too extreme. And what he actually says is, that, as to that 10%, we have some basis for thinking they're making economic decisions. He doesn't say that means that the above minimum fee regression is accurately mapping 100%. And again, I mean, but even putting aside what Tyler said, I mean, overwhelmingly, the actual results here show the absurdity. 55% confidence interval. That's ridiculous. No scientist would accept that. The board does not suggest that any scientist
Can
would
I ask
accept
about that? So and just help me understand
Yeah.
this. So what the board says at JA 511,
Yeah.
if the judges take note of the 55% confidence level and then go on to give a statement as to why, what does it mean to take note of it? Because when I'm looking at the table, I see a 55% column, I see a 90% column, I see a 95, and I see a 99. Of course, the range gets narrower as you go to the left because the confidence is getting less. So
Right.
that makes sense to me as an intuitive matter. But there's also these other columns. And so the columns all have ranges in them. But to the extent that the board took into account the regression, I don't think they took into account a range. I think they took into account some value that's in that range.
Right.
So if they took into account some value that's in that range, and maybe it's the left-hand most column, what's labeled the share. I'm not sure. You can tell me about that. But whatever the value is, it's in that range. If it's in the range of all of them, what does it mean when the board says, I'm taking note of the 55% column when the value that they're ultimately using, to the extent they're using the regression for a particular category, is also within the range for the other confidence intervals too?
Right. So, I mean, if you look at like the 95% confidence interval, right, for commercial television, right, which for 2015 is between 7% and 15%, and for 2016 is between 6% and 20%. So the regression isn't telling you anything about the particular confidence that the actual value for CTV is any particular number within that range, right? What it's telling you basically is that, if you repeat this 100 times, 95% of the time, you're going to get some number in that range. But the level of imprecision here, maybe commercial television is 6%, maybe it's 20%. I mean, that's an enormous level of imprecision when you're trying to allocate 100% between 6 different claimant categories. And again, that is one of the categories the board said could be accurately measured. It acknowledges that these numbers are wrong for sports devotional Canadians. I mean, for Canadians, it says they're so wrong that we're going to splice back in this prior regression that we just said is completely bunk. For sports, even at the 55% confidence interval for 2016 and for 2017, the numbers are, the range is negative, right? And so that's really remarkable. What this regression is doing is, even at the lowest amount of confidence, even if you're just saying we have the confidence of a coin flip, it can't exclude the possibility that having sports lowers the value. And that's just wrong. And that shows that the regression is wrong. I think it's also the case that every single economist, every single regression expert, other than Dr. Tyler, said that the reason this regression is totally wrong is because it's trying to regress minutes of sort of a category against this rate that's set by a statute that isn't a market price. And so it's just mimicking the statutory formula. There's no reason, even putting aside the total imprecision here, there's just no reason to assume that the numbers the regression is spitting out are actually reflecting the marketplace value of a minute, right? So there's the imprecision issue. And then there's the question of like, well, you have a regression and it gives you some numbers that say you multiply minutes of a content category by your coefficient, which is supposed to be the marginal value of a minute, and then you get the end result. You have to have some economic basis, some rationale for thinking that those coefficients actually represent the marketplace value of a minute, as opposed to just representing some correlation that's totally unrelated to marketplace value. And so this is what Dr. Rubenfeld, who's this economist from Berkeley, he's the one who wrote the regression chapter for the Federal Judicial Center's Manual on Use of Scientific Evidence.
And the board dealt with his testimony.
I'm sorry?
The board addressed.
No, the board did not address this issue, Your Honor.
They certainly talked about what he said and what his opinion was.
So I think the board says at some point that it will address the arguments that Tyler's regression just mimics the statutory formula. See infra. That's what it says. And if you go to infra, there's no actual discussion of this particular point. They don't.
Go ahead.
They did discuss the expert testimony that was offered.
Yes.
By two, not only Rubenfeld, but the other fellow.
Yes.
All right. And had problems with it. So it's not as though it ignored it, but I just want, is the result of your analysis here that the board had no choice other than to use surveys?
Our view is that the survey was the best evidence on this record.
That's right, because the board says, after it goes through its explanation about why the Tyler sensitivity analysis is what it's going to follow with all these adjustments. It says, and none of the other regression analyses were pressed upon us. All right, so it views it as, even though people proposed these other ways of looking at it, there were all kinds of problems there, which the board discussed. So they were left with Tyler with these various adjustments. But your point is that because we come up with these ridiculous, absurd results, it's clear the board had no choice other than to use the survey.
That's right, Your Honor. We're not suggesting that any of the regressions the board rejected were better. Our view is that given the actual data in this context, you just can't use a regression. You can't.
Can I just make sure I understand your stake in this? So as I understand what the board ultimately did for JSC, actually the regression didn't play much of a role in pegging the JSC number. It played more of a role in the PTV number. And then the point for you is, well, if it played a role in the PTV number, then it necessarily played a role in our ultimate allocation too, because we're talking about a zero-sum game within 100.
Correct.
But where you get there is, if they didn't, in other words, excluding the regression altogether, it might not actually affect very much where the board started for CSC, at least, if they based CSC on the survey. But it would affect where the board could have started with PTV. And if it affects where the board could have started the PTV, then it necessarily has a feedback effect on you.
That's correct, Your Honor. And our numbers were lower than the numbers that our ultimate sort of synthesized numbers were lower than the numbers that the board awarded us under the adjusted survey that the board accepted. And every year they were lower than our survey numbers. And in 2014, they were lower than our regression number and our survey number, which I think no one has any response to, or no one has any explanation for why that's non-arbitrary.
I think there is a response to that, actually.
Okay.
Because I thought just on that narrow point, it may not affect the rest of this, but I thought what the board said in the reconsideration decision, that maybe this is irrelevant for a reason I'm not exactly following, it's on JA 562, is that in 2014, the allocation summed to marginally greater than 100%. And the judges therefore adjusted the allocation shares proportionally to achieve an aggregated allocation of 100%. In 2014 shares, this process required a modest downward adjustment. And so if it requires a downward adjustment, then am I not understanding this right? Then you could understand why it would go lower.
That's in response to a different error. So they made an adjustment that I think that was an error raised by PTV, that there was some mistake in 2014 that the numbers didn't add up to 20 to 100, and they changed the adjustment so that the value for JSC in 2014 in the initial determination went very modestly up in the final determination.
I didn't understand this to be a response actually to a particular error. I thought this was just a general method that they followed because they had to get everything to add up to 100. And for 2014, all the numbers total together exceeded 100, so they had to reduce them all. But we can.
I don't think that that's responsive at all to the point that we're making, which is that our number is lower than both of our allocations under the what the board purported to.
Right, I understand that point. I thought this would potentially.
I don't think it is. I mean, the government certainly didn't argue that it was, and it's not. And I don't think it's the case that anybody else's number was lower than both of their numbers.
Can I ask you about sports in particular? Because you raised this question about, and the negative values is another thing. I mean, I take the point on a negative value being potentially surprising, but in terms of the sports value going way down after 2014, if I understand the context, what we're talking about is retransmission of local broadcast, right?
So let me address that.
If I can just finish what you may already anticipate where I'm going with this, but if WGN was the big elephant in the room at this point, I take it that what that means is that people in California who want to see the Cubs, local broadcast of WGN to them is how a person who moved from Chicago to somewhere else can see the Cubs. And it turns out that that was the one that was doing all the work in this area. I mean, I don't even think you dispute that taking WGN out of the field of vision had a pretty dramatic effect on the value of retransmitting local channels, because this was the local channel that actually turned out to be the one that was left that everybody cared about. So if that's true, it doesn't seem to me to be altogether surprising that after taking WGN out of the field of vision, because it's no longer broadcast, it's not going to be on cable, then there's just not that much left that's locally available that needed to be rebroadcast for people to see. We're not talking about the World Series. We're not talking about the Super Bowl. We're not talking about those things. We're talking about the rebroadcast of a local feed, of which WGN was the major one.
Yeah, so let me address that. And we are talking about the World Series and Super Bowl, and I'll turn to that in a minute.
Sure.
But with respect specifically to, so the number of unique live sports games that are retransmitted every year in 2015 to 2017 is 2,200 unique live sports games a year. That's at SJA 15 and 121 to 122. That is more than the number of unique live sports games that is transmitted in 2014. So what the difference between WGN and the rest of the stations that are being distantly retransmitted is that WGN is being retransmitted because it's a superstation. It's being retransmitted to many more subscribers across the country. That's the issue, but it's not different in kind. So WGN is retransmitting, Cubs, White Sox games, that sort of stuff. So let me talk a little bit about what is being retransmitted in 2015 to 2017 after the conversion. So it's the same kind of thing. So this is at SJA 123 to 130. So what's being retransmitted here is New York City channels that carry Mets and Yankees games are being retransmitted to subscribers in Philadelphia, New Jersey, upstate New York, who don't have access to those games. Same thing for Giants and Jets games. Fox and NBC affiliates in Philadelphia that are carrying Phillies and Eagles games, those games are being retransmitted to other areas of Pennsylvania, New Jersey, Delaware, other places where there are likely to be fans. So LA, one of the channels that's being retransmitted here carries Dodgers games to other places outside the LA metro area where the Dodgers are popular. There's the NBC affiliate here in DC carries preseason Commanders games. That's being distantly retransmitted to places in Maryland, Virginia, Delaware that are outside the range of the local DC signal.
Were those are just preseason? I just want to make sure I understand the
I think that the particular example in the record there was preseason, but all of the other examples I have given are not.
I mean, I watch preseason, but that's a level of fandom.
Yes.
Maybe different.
All of the other examples I just gave you were in preseason. Okay. There's a station that carries Notre Dame football to subscribers that's being retransmitted to subscribers in Ohio and Kentucky. So
if I take all this to be true, then are you, I thought everybody was kind of operating in common ground that the elimination of WGN was a significant deal. But if we're talking about the New York sports, we're talking about LA sports, we're talking about Notre Dame football, none of that, I take it what you're saying is nothing changed with respect to any of those. If that's true, then I thought even your own proposal recognized that there was a significant shift when WGN gets taken.
Yeah. Our proposal recognizes that there's a shift because there are just fewer subscribers total who are getting this content, but the content is no less valuable. And let me talk about the World Series and the Super Bowl, because the government, I think, says in their brief, this isn't what that's about. That's just completely wrong. And I don't know where they got that. So there are a number of subscribers who do not have a local Fox signal. And when Fox carries the World Series, which it did in 2014, 2015, 2016, and 2017, those subscribers are only getting the World Series through the Section 111 retransmissions. That is also the case for the Super Bowl in 2014 and 2017 when it's carried on Fox. This is at SGA 130. So this absolutely includes the World Series and the Super Bowl.
I mean, it could include those but if it's for dramatically limited numbers of people, then why doesn't that matter? Of course, the value of sports in the abstract. I mean, it's sort of like saying if one person in America can only get the Super Bowl through a retransmission of a local broadcast, then yes, the Super Bowl is really, really, really valuable. There's no doubt about that. But if it's only one person that we're talking about, then for these purposes, it doesn't seem like we'd reflect the value of sports in the abstract as the relevant criteria.
We're not disputing that the value of sports should have gone down because the quantity that was retransmitted went down, and the survey does reflect it. It's just that it doesn't go down as much as the board found. And so, in particular, and I think one of the relevant points here is that scarcity in this context often makes things more valuable, and also that when people are getting television, like it doesn't really matter that you might, you're getting 30 extra hours of Seinfeld reruns that you can watch on Netflix, or getting 60 extra hours of Seinfeld reruns that you can watch on Netflix. There's no real difference in the value there as compared to the 2 hours of a live sports game that you can't watch on Netflix. But so
I wanted to get some sense of you back again about you talking about this regression analysis, because that's long been used to infer value. So are you saying that there should be a categorical denial of that type of process, and you prefer that we only look at surveys, or are you just attacking the regression analysis here?
Yeah, we're not saying that the court has to conclude that no regression ever in this context, no matter what. What we're saying is that given the data here, where you have to throw out 90% of the transmissions, and given the absurd results that it produces, you can't use a survey in this context. And given the fact that you don't actually have a
You can't use regression.
I'm so sorry that you can't use a regression in this context. Thank you for that correction.
Okay. Go ahead.
And can I just, if
I just wanted to, there's going to be winners and losers, just like there is in sports. And so what are you taking us to in terms of a specific approach that is fair across the lines? Because there was a lot of information in this record.
Yes.
A lot of deference to statisticians, other experts, et cetera, that the court generally refers to as long as it's reasonably explained. And so do you have a specific formula that you're asking us to go to that, makes it fair to all parties, not just the show?
Yes, we think, so, and I know I've gone way over my time. I would, if I can, like to talk about the survey adjustment problem for a few minutes if I can. But we think that the court should hold that on this record, using the regression was arbitrary and irrational. We think the court should hold that the survey, as the board found, is something that gets directly at marketplace value by literally asking the cable systems what the marketplace value is. We think the court should remand for the board to reconsider the adjustment that it applied to the survey. And let me talk about that for a few minutes.
Can I just ask you though
Sure.
a question? You've got the board making some findings at JA 546. They say they categorically reject JSC's argument that they acted inconsistently and thus clear error by giving less evidentiary weight to minimum fee royalty. You can read that and you're probably more familiar than I am. But the point is, we need to do something, or you need to be able to give us something in response to that, because the board is saying that, your own witnesses don't support your own argument.
Yeah, I don't think what the board is saying here is a reasonable explanation. I'm just trying to figure out. It's on J 546 because it's, as you know, it's a long opinion. So I'm just looking at J 546.
It's in column A,
Mm-hmm.
and it's the judge's categorically reject.
About halfway down the column, yeah.
And they take each of your arguments and they say specifically JSC argues on rehearing that.
Yeah, so this is a response on this issue of the McLaughlin adjustment that they applied to the survey. So let me just talk about that for a minute. So that adjustment takes every PTV only system and assumes that it values PTV at 100%, even if it's barely transmitting any PTV to subscribers. And even if that same system had valued PTV at 8% in 2014. But I think the main point about this survey
But that adjustment's been used for a couple of decades.
Yeah.
Adjustments have been used previously, but they never made any difference. So in 2014, we're not objecting to the use of this adjustment in 2014. It changes the sports allocation by like 0.1. So it just didn't make any difference before. And now it does make a difference because there were a lot of systems that were PTV plus WGN, and now they're PTV only. But you don't have to agree with anything I say. All you have to do is take what the board said about why the adjustment it applied was arbitrary and capricious. It says, quote, there is no rationale for
Where are you
augmenting.
quoting from?
This is J 537. It says, there is no rationale for augmenting the survey results with the McLaughlin adjustment for all the PTV only systems that come into existence after 2014. That's what it says. And that is why it refuses to credit the McLaughlin adjustment for PTV. The McLaughlin adjustment in 2015 to 2017 would have raised PTV's average allocation from like 7.5% to 46.7%.
So this is in column B, right? Sort of in the middle. Yet with respect to PTV. Yeah.
Yes. Yes. With respect to PTV, basically what it is saying here is that the McLaughlin adjustment produces such an absurd increase in PTV's numbers that we refuse to credit it for PTV. And so if that is true, it is completely arbitrary and inconsistent to use that exact same adjustment to lower sports' value. And that's what they're doing. And nobody has any response to that. The board, Your Honor, Judge Rogers, the board has not responded to that point. And the government has not responded to that point at all. Nobody can explain why it's recent decision-making to say this is crazy, but we're going to use it for sports. And there are like a number of obvious reasons why it's totally crazy to make this assumption. So a full third of the PTV only systems are must carry. They're literally required to carry PTV by statute. And then 57% of the PTV only systems are actually only carrying PTV locally, just in the same way that they're carrying stations that transmit sports locally. And there's just this bizarre statutory quirk that says when you carry PTV locally, it counts as distant. So nobody's making any choice to carry PTV over local commercial stations with sports and news and movies in those systems.
The upshot of this is just if I'm understanding the overall architecture of the argument, it's that the board shouldn't consider regression at all. It should only consider survey.
Yes.
But actually, it shouldn't consider survey in the way that it considered the survey. It should consider the survey in the way you want them to consider the survey. And the way you want them to consider the survey is they can't do the McLaughlin adjustment. That's part of it. That you have a problem with the adjustments to the survey that they made.
They can't do the version of the McLaughlin adjustment that they did. We've proposed 2 alternative adjustments that we think
Adjustment
are.
1 and adjustment 2.
That's right.
Yeah.
And again, we would be totally fine with the court remanding for the board to pick a different adjustment. I mean, I think, the import of this court's decision in the settling devotional claimants cases, the board can't just say, well, we have bad evidence, so we're picking something. It can't do that. So I think that it's very, very clear on this record that the adjustment the board chose was arbitrary. And so,
Look at column C.
yes,
This is still on 537.
yes.
So ample evidence in the record that SDC provides niche programming, blah, blah, blah. And that niche value of SDC has been reflected well in the board's surveys received in this proceeding. Do you see that?
Yes, Your Honor.
So, I mean, they heard you, but they said they thought the value was reflected well.
So for the settling devotional claimants, they said that the survey reflected them well, but that's different than for the for
JS,
PBS.
yeah.
And that's really where the rubber meets the road with this adjustment, where they say that adjustment is absurd. And, I'm happy to talk about our 2 adjustments. I mean, I think they were good adjustments. I think, I think it's pretty clear that the board's reason for rejecting our second adjustment, which was that we hadn't offered it, is just totally wrong. It's right there in the record. But I know I'm way over my time. So
Then can we just talk for a minute about a point that I think you noted and then briefed, but we haven't gotten to yet, which is the way that all this gets hashed out in the end.
yes,
And put together, because I take it part of your submission is, and this is most evident on this same page, J 537, and then on reconsideration at 561, 562, I think, is the board, I think what it did was it thought that the survey results were particularly helpful with certain groups. And I thought that the regression was particularly helpful, at least with PTV. And I can't remember, there were many others as well.
Yeah.
And it indicated that, at least for certain years, that it was going to give a special weight to one or the other for a particular group. I'm not sure that we know, and we can ask the government about this, was given, but there was an indication that it was going to get a lot of weight, maybe dispositive weight, maybe heavy weight. It's kind of words along those lines were being used.
right.
Is it your submission that unless we know exactly the weight that was given to either the survey or the regression for each grouping, then the resolution has to be set aside? Or what are you basically objecting to? Because I think I've summed up the problem that's been identified, which is, there's some kind of qualitative suggestions that we heavily relied on this, we heavily relied on that, we dispositively relied on this. But when you look at the survey results and then you look at the regression results, neither of those is reflected in the ultimate allocations. You can kind of think that it's pretty close to one or the other in certain situations, and others further away. We don't know exactly how these final figures are being arrived at. We just have some kind of description of roughly how they're being arrived at, which leaves a fair amount to the imagination, I thought was what you were suggesting in your brief. And I'm just wondering, what's the upshot of that? What do you think the board has to do, at least as a minimum?
Look, I think if it provided the actual weights, the actual numerical weights, that would be the best. I guess I'm not sure whether there's something short of that it could do. I think that what it did do is it offered a description of the weighting process that was inconsistent with the results. So I think we cited one example, like they say they're weighing survey evidence heavily for both CTV, which is commercial television, and program suppliers, but the program supplier allocation is like halfway between the regression and the survey, and the CTV allocation just matches the survey. For PTV, it says it's giving dispositive weight to the regression, but PTV's allocation for 2015 to 2017 is higher by nearly 3 points every single year than the regression, than its regression allocation, while JSC's allocation is lower every year than the survey that the board said it was relying on for us. So it's just not consistent with what they said. And I think if they provided some more detail about what they were actually doing, I think that would be helpful for the parties in the court to figure out whether what they were doing was non-arbitrary. And again, I think the 2014 example is really reflects the arbitrariness here in a
That's
quite
the
clear
one
way.
where the sports ends up lower.
Lower than
than
both,
either.
lower than both. And I'll take a look while the other parties are going at the particular page you
Yeah,
identified.
and that might be.
But again, I mean, the government didn't identify that page
Yeah,
as
and it
a
might be totally
response.
off, but it's just, yeah, okay.
Yeah, so
That's why I started where I did with a question to you. And
Yeah.
that's where the chief is ending. All right. And part of the problem is what we have before us is the board's response to the objections as it understood them, and a fairly lengthy statement about why it rejected one, went with the other, tried to come up with something that it thought made sense in these circumstances. And from time to time, it says, look, we've acknowledged this, we've acknowledged that. The parties acknowledge, and what the parties haven't done is to give us anything that we think comes up with the appropriate allocations. So just to send this back to the board isn't enough. And I thought that's where the chief's question might be headed. Because we get records like this all the time. And every time I sort of looked for something, I can find something in here where the board has addressed the matter. But whoever the claimant is doesn't necessarily agree with that analysis. But that's different, even on an APA review. And so, what are we signaling to the board if we say, look, you gave us, I don't know how many pages, fine type. You may not like their answers, but they didn't ignore anything.
So, I mean,
And so, just so let me finish, so you know what I'm getting at. And when the chief says, at the bottom is your point that we need to know why it put numbers in one place or another. But I thought the thrust of your argument today is that's not going to do us any good because the analysis itself is faulty. So telling us, where you put the numbers based on that faulty analysis, that's not going to resolve anything.
I absolutely agree. And I think that that colloquy was just about our sort of third point. But our fundamental submission is that you can't rely on the regression at all. And obviously, if the court holds that, it would avoid the issue about the synthesis. But our fundamental submission is you can't rely on the regression at all. And
well, the board tells us you can't rely on the survey either. And it says why.
I respectfully disagree, Your Honor. The board does rely on the survey.
I know, but it says it's got to make all these adjustments.
It makes one adjustment for the survey. It makes 3 very ad hoc adjustments for the regression. And I think that,
I know. One big one and 3 little ones is 2 different things, depending on who is the claimant arguing here. So they say, the board says, here we've looked at this survey and it's still fine that the Tyler model is the most appropriate regression model in this record and have accorded it the most weight. This is again 537. And then it says the board surveys provide relevant illustrations on the distributions. But, and then it goes on. So, I mean, it isn't enough were we to say, for hypothetically, well, you can't rely on the regressions, but just use the survey data.
So of course, I acknowledge the board says that the Tyler regression is the most appropriate in this record. And we agree that all of the other regressions are inappropriate too. But I mean, our fundamental submission, Your Honor, is that it was arbitrary to say that the Tyler regression was appropriate here. It may have been the most appropriate.
I understand that, but I thought, and all three judges have asked you this question, and you said you want the survey data. That's what the board should have followed. All right, but the board says there's some problems with the survey.
Yes, the board does say that. And I think that the question on remand, if the court agrees with us, would be just simply what's the right adjustment. But I will say the adjustments the board made to the regression are enormous. They're not small. And it's also the case that, so the adjustment that needs to be made to the survey is to account for the fact that there's like, some of these PTV only systems. It's a small number. It's like 20%. It's like there's like 170 or so PTV only systems, and there's like 940 or so total systems. So that's 20%. Whereas what's being thrown out of the regression is 90%. And one thing to note is that what's going on in the regression when the board is making these sort of random ad hoc adjustments is none of them are actually aimed at trying to figure out what those 90% that are being thrown out think. They're much more specific than that. There's like the random adjustment to splice back in something for the devotional claimants, and then there's a few PTV specific adjustments. But the board isn't suggesting that there's any possible way to adjust the regression to account for the fact that it is throwing out 90% of the entire data. And that's different than the survey, where there's a much smaller adjustment that's needed, and it's specific to a set number of systems, and you just have to figure out how to figure out what those systems think. So
when you say 90%, you're talking about narrowing it to only the above minimum.
Correct, Your Honor. Who are not representative of the rest, and frankly, that's the whole point that the board is making, is they're not representative.
Yep.
Yeah.
Okay, we'll make sure there's no additional questions from you at this point. We'll give you a little time for rebuttal.
Thank you.
Thank you, counsel. Dove?
Morning, Your Honors. May it please the court. My name is Ron Dove, and I represent PBS and the public television claimants. I'd like to reserve 3 minutes for rebuttal. The public television claimants are a large and diverse group of copyright owners, including the producers of Sesame Street, Downton Abbey, American Experience, and thousands of other high-quality programs. These programs made up the large majority of Section 111 distance signals during the 2014 to 2017 period, reaching as high as 66% of all retransmissions by 2017. But instead of allocating public television a share of royalties commensurate with this dominant market share, the judges awarded public television only 11 to 25%. And the judges reached that erroneous result by adopting a zero-value approach to minimum fee cable systems and must-carry signals, impacting far more public television programs than any other type. The judges used, as we've been talking about, used a regression that calculated the price per minute for each type of programming, multiplied by the number of minutes of that programming. And that part was fine. It's basic economics, price times quantity. But when applying that regression to the facts here, the judges discarded millions of minutes of public television programming, not only in estimating the value per minute, but also from the quantity of retransmissions, all because they claimed that as a category, those minutes had zero measurable value. And they then gave this regression evidence dispositive weight in determining public television share for 2015 to 2017. So the judge's approach was erroneous for two fundamental reasons that are narrow reasons, actually. First, with respect to minimum fee signals, the zero value approach marked an unexplained departure from precedent that was contrary to all the evidence. The judges then compounded that error by improperly excluding retransmissions from minimum fee cable systems, only to restore all that value through adjustments for every claimant group except public television.
So just to understand the context here, I mean, I take it you don't disagree with the basic idea that because a must-carry obligation is a part of the mix here, that the analysis should try to figure out what role the requirement to carry might have in the marketplace. I mean, that it could have some distorting effects, that it's not a free market decision to carry, it's a requirement to carry. And therefore, what we're trying to do is market the value that if we're trying to do is estimate the value that the market would place on it, we should do something to account for the fact that some of this might be coming about because of an obligation rather than an estimation of what the market would otherwise accommodate.
Well, Your Honor, it's not irrational to look into that issue.
Yeah.
And all the parties presented different methodologies. Even the board survey, for example, cable operators were surveyed even when they carried must-carry signals, and were asked to value what those must-carry signals were. Public television put it in its own methodology, that regression methodology that looked at that. In fact, all the experts did that. It was only other claimants then looked at it and tried to discount from those methodologies to account for must-carry. But with respect to must-carry signals, the judge's zero-value approach was based on a fundamental misreading of the must-carry statute, in our view. The judges assumed that must-carry signals had zero value simply because they were must-carry signals. But Congress made clear that copyrighted programs on must-carry signals are valuable and compensable under Section 111, and the record evidence confirmed as much. So I want to go now to the minimum fee in a little bit more detail. In particular, I'd like to draw the court's attention to the 2010 to 2013 allocation decision, which immediately preceded the one at issue here. There, the judges explained that minimum fee systems do reveal value, and they adopted a regression that included those systems. But in the decision below, the judges did the exact opposite. They asserted that minimum fee systems lack value, and they adopted a regression that stripped out those systems.
But didn't
Yes,
that
Judge.
predate the WGNA factor into this case?
It did, Your Honor. The 2010 to 13 time period was before the WGN
So we needed
situation.
a shift, some adjustment.
There was definitely an earthquake in the marketplace. With WGN being removed as all of this programming that was not public television, sports programming and other programming, was removed from the distance signal analysis. So it was a shift.
Why would the prior precedent be controlling when you've got this major catastrophic shift?
Because because the prior precedent was based on general economic principles that didn't really relate to the facts in the record. The 2010 to 13 decision recognized that there is value in carrying minimum fee signals because there are physical costs to if you choose to transmit a signal, there's a cost associated with that to actually retransmit it. There are opportunity costs. You're choosing one signal, say a public television signal, over another signal that you could have chosen. And so the panel talked about that distinction from a matter of economics as to why these minimum fee signals reveal value. The judges, in this proceeding, removed millions of minimum fee minutes in determining both the price and the quantity. And this impacted public television disproportionately because it had many more minutes excluded, including every single minute from every cable system that only carried public television, which was more than 30% of all systems by 2017. And worst of all, Your Honors, the judges claimed that they were following the exact same approach that they followed in the 2010 to 13 decision, as we just discussed. And that's a textbook change in position violation. No one in this room, not the government, not the joint sports claimants, not the interveners, has explained how it's not. And they do. They say that this violation can be excused because there were lots more minimum fee signals in 2014 to 2017 than in 2010 to 13. But that just makes the error more egregious. Because it means that more valuable data, the 90% of data that we were just talking about, more valuable data was discarded. In any event, the judge's minimum fee approach was contrary to all the evidence. Indeed, every claimant expert concluded that minimum fee signals reveal at least some value, yet the judges still excluded those signals, the quantity of those signals from the analysis. I could turn to must-carry signals. The judge's zero-value approach to must-carry signals was unlawful multiple times over. For one, it was contrary to the must-carry statute. That statute expressly contemplates that must-carry signals can generate increased copyright royalties under Section 111. And the government doesn't dispute that. It attempts to defend the judge's zero-value approach by saying that there wasn't record evidence establishing that must-carry signals have value. But all of the surveys and the regressions that the claimants proposed revealed that must-carry signals have at least some measurable value. So how did the judges end up where they did? For the judges, the statute was the evidence. They simply assumed that because there was a statutory requirement to carry the signals, those signals could reveal value. Or excuse me, those signals could not reveal value. But Congress determined otherwise. It contemplated that royalties would be paid and allocated for must-carry signals. Now, as for the interveners, they would conveniently have public television stations pay royalties into the Section 111 pool for public television's own programming. And they would then have those same royalties reallocated to other claimant groups with no copyright in those programs. And that's what we're talking about here, is compensating copyright owners whose programs were actually carried, not in some hypothetical world, but actually carried by cable systems. In other words, the interveners want a windfall, but that's not the scheme that Congress designed. As with the minimum fee issue, the judges not only adopted a flawed zero value framework, they also applied that approach in an arbitrary way. To identify must-carry signals, the judges relied on a fundamentally flawed methodology advanced by JSC's expert that no one except JSC defends. And when confronted with these flaws, the judges, they acknowledged the flaws, but they shifted the burden to public television and applied an adverse inference. And they required public television to supply a reliable methodology for identifying must-carry signals after the hearing was closed, even though public television's proposed methodology already placed value on every signal. And there was no need for public television to identify must-carry signals in particular. So the judges got things backward. It's the judges who must support their decision with substantial evidence. And if any party has had a burden to identify must-carry signals, that was JSC, the claimant group, contending that those signals should be stripped of value.
And for these purposes, are we talking about the regression? Or what exactly are you talking about with respect to?
With regard to must-carry signals? Yeah. Yes, we're talking about the regression. They're the must-carry in adjustment B. Right. The must-carry, both the quantity of must-carry minutes is removed from the allocation. So that for regression purposes. Yes.
So I mean, what we're supposed to be looking at is whether what the board did is arbitrary. And on JA 468, the board says, it notes that Doctors Marks, Bennett, and Major all agree that including PTV must-carry solutions in the regressions results in an overestimation of the value of PTV content for all 4 years. So they're relying on experts who have come forward and said that putting must-carry into the regression analysis in this way is going to overestimate.
Right, but the way that they do that is they attribute zero value for must-carry signals. In other words, even though every expert accorded some value to must-carry signals, the judges adjust for it by totally zeroing out all must-carry signals from the quantity of must-carry signals from the analysis in adjustment B. There's no, despite all the evidence of, that must-carry signals do have value, and despite the fact that Congress, in enacting the Cable Act, made it clear that distance carriage will result in that cable operators are to pay royalties for the distant carriage of must-carry signals. Despite all that, the panel decided that it should be zeroed out entirely, and that's why we view that to be arbitrary.
At 469, doesn't the board say that's not what they're doing? Let's get it. front of me. It says it's not doing zero value. It's just saying in the regression analysis.
Excuse me.
So it's 469 in column C, they say, the point is not that the programs on must-carry stations, including those subject to royalty indemnification payment back to the CSOs, lack value. Rather, the point is that they lack objective and measurable value.
Yes, Your Honor, and that's, and that's not, that's not true. They do have objective and measurable value that every expert included.
Yeah. And the board talks about the experts that you called and says the experts for PTV and CCG mistakenly seek to analogize must-carry PTV stations to TWO must-buy carry PTV stations to must-buy automobile attributes, seat belts, and airbags, and to must-carry health insurance, which comes at a cost. There are two problems with this argument. And then they say first and second. So you're familiar with that.
I am familiar with that argument. Yes, we'd made
yes. They don't. Your argument is broader than what the board did.
Well, the board did not articulate the overwhelming evidence in the record that was credited by the judges showed that must-carry signals have value. For example, the board survey that we've talked about, the judges credited that survey as a methodology. In that survey, over 95% of cable operators that retransmitted purportedly must-carry public television signals and that responded to the board survey indicated that those signals had value. They placed a number on it.
And so they go on to say, and that it would improperly count the distant signals from which the PBS indemnified the cable operators. So that's their point about they can't be measured. And you're saying that's just wrong because your expert said it could be measured.
No, well, I think, Your Honor, for example, I talked about indemnification there. I think they just didn't understand how the indemnification worked. For a must-carry signal, and we lay this out in the briefs, for a must-carry signal, if a cable operator has to pay the royalty for that distant must-carry signal, but it can choose under the Cable Act, it can choose to seek out indemnification from the public television station that's being retransmitted. Okay, so cable operator pays, cable operator may get that money back if it chooses to seek that indemnification. But that money that was paid for public television programming. And it still needs to be distributed. It's still in the royalty pool. In many cases, it's the only distant programming that's carried by the cable system is this one public television programming.
So when your argument then is in part that the board is just doing sort of a double speak here because it's not really addressing your argument. Is that your point?
In that particular instance, yes, Your Honor. I think that's a good summary. One final point, Your Honor, and this gets to the sort of what are we asking the judges to do here? The government's basic approach to the case is that it's complicated and the judges wrote a long decision, and so this court should affirm. But a complicated record is no excuse for arbitrary decision-making, and there were simple, straightforward valuation approaches that were in the record and that the judges could have adopted and applied to all parties without violating the APA. For
And
example,
so that the synthesis that the board adopted is the problem.
the synthesis that the board adopted is part of the problem. They're cherry picking one place, cherry picking another place. We need to have consistent application of these methodologies.
So what would you be asking the board for?
Well, what we would ask the board to do is to remand with instructions to issue a new decision that does not apply the judge's flawed zero value approach.
Oh, I've got that, but I mean,
Okay.
what I'm getting at is we pushed council to what they really want. They want to use the survey. So what is MP?
Well, what we would want them, send it back to the panel and they will have a choice. They will look at that based on the instructions you give. They could have adopted, any of the regressions that included, as long as they include minimum fee signals and must carry signals. They could have applied the McLaughlin adjusted board survey to all the parties, including public television, as they've done for the past 2 decades. Or they could have combined, those approaches as long as they explain what they did and treat all the parties fairly. Any of these methods would have afforded at least rough justice in estimating what Section 111 requires.
What I'm getting at is we have a board that says that's what they've done. And council are arguing we have to grant the petitions because the board hasn't adequately explained and it's rejected things arbitrarily. So my point is, you send it back and we get another 4 volumes of an opinion. And we're faced with the same sort of problems. And I'm trying to get some sense of narrowing here so that we don't just get that. And we also don't get, a 1-page order that says, we affirm our previous decision.
Well, Your Honors, I think the panel needs to explain, but really what I'm asking them to do is they could apply the Tyler model, all right, without, excluding minimum fee and without excluding must carry, right, based on my arguments here. And then that is entirely consistent with the board's survey results as adjusted by the McLaughlin adjustment, which as it's done for the last 20 years.
So one side says, apply the survey, period. The other side says, well, not quite. We want some adjustments.
You mean as to the board survey?
Yes.
Yes. I mean, we not just want, the board survey is biased against public television. Everybody
I didn't
recognize that.
want as a personal preference, but rather that you think it's legally required.
Yes, it's literally required. It has to be adjusted. And that's why the panel's done it for the last 20 years. There are, I think it's 33% of the systems only carry public television. In those situations, that's the only copyrighted programming that's being retransmitted. And what the McLaughlin adjustment does is says for those situations where we're dealing with relative value, the relative value of public television on those systems is 100%. It has to be by definition. There's no other, maybe WGN used to be there and there were sports that used to be on that distant signal, but no more. It's 100%. And so it's a very, simple and appropriate adjustment to make and should be applied here.
All this data available to it. It applied it to each claimant's situation as relative to the circumstances. They looked to expert testimony. You're asking us to kind of substitute our judgment for that expert testimony and then come out with a different result. But I'm not finding, based on Judge Rogers' question, what law or what weighing of substantial evidence that you want us to go after. You just all seem to have a different approach as to how the board weighed all of this, even with respect to them looking at other experts and utilizing what they deemed appropriate or not in the experts' testimonies.
Your Honor, at least from public television's perspective, it's much narrower than that. Our argument with regard to minimum fee systems is that this is a classic change in position. The panel adopted an approach in 2010 to 13.
Which we've explained becomes different because of the WGNA
Well,
explosion.
but the laws of economics don't become different, Your Honor. Yes, the number of systems is different, but the laws of economics and just the fact that there are opportunity costs and physical costs and other costs that actually demonstrate value, that prove that these systems have value. That doesn't, I mean, that stays the same. And yet they completely reverse themselves and excluded millions and millions of public television minutes from the regression analysis. And that's millions, that's minutes, that's copyrighted programs that are to be compensated in these proceedings. And that's what happened. And that is why that is arbitrary.
And just curiously, have you done an analysis that if that was placed back in, how everybody would come out?
I mean, yes, Your Honor, it's actually Tyler himself did that analysis. It's the model that Tyler himself preferred and advocated in this proceeding. It's the
It's not
his
the
preferred
sensitivity model.
No, not the sensitivity model. The model that he actually proposed is the model that resolves these problems from public television's perspective.
My colleagues don't have any additional questions for you this time. Okay, thank you, Council. Give you some time for rebuttal as well.
Thank you.
Hear from the government now. Ms. Carson.
Good morning. May it please the court, Sonia Carson for the government. The copyright royalty judges acted reasonably in applying a flawed record to the difficult, counterfactual, hypothetical question of relative marketplace value for an industry in which no free market has ever existed. The fact that all of the evidence in the record was flawed does not mean that the copyright royalty judges could not rely on it. Here, the agency conducted a month-long trial in which they admitted hundreds of exhibits, considered testimony from dozens of experts, and wrote a painstaking opinion acknowledging the flaws and accounting for them as best they could. The argument, as I think the colloquy with the appellants shows here, is that the judges should have weighed some evidence more heavily than others in predictably a direction that favors the party who is advocating for their preferred position. But the problem here is, of course, as the judges exhaustively explained, that none of the evidence in the record is perfect, and perfect is not the standard. The standard of review here is whether the judge's allocation of royalties was reasonable, supported by substantial evidence in the record, and here there can be no serious doubt that what the copyright royalty judges did was, for example, account for the fact that the Bort survey just has a data gap. It's always had this. The JSC commissioned this survey, and the Bort's media company excluded every cable system operator who retransmitted only either PTV content or content from the Canadian Claimants Group. Now, this is a gap that, because it has existed before, the McLaughlin adjustment was developed as one way to address it. JSC came into this proceeding with a survey that they chose to conduct in the same way, and the judges have to take the record as they find it. This is not the government's money. We get involved in these cases because the parties are unable to settle among themselves how the royalties should be distributed. And the project for the judges here was to take a look at all of the evidence that was in the record and decide as best they could what reasonable ways to approximate the entire market as a whole. How would a regression model sort of best approximate this hypothetical counterfactual industry that has never existed? How would a survey model sort of best approximate a hypothetical counterfactual free market that has never existed? And then individually, with respect to each claimant group, how persuasive, how well does each frame of vision, whether it's regression or survey, map on to the type of content that the claimant retransmits?
But can we start with I do have some questions about how it all got brought together.
Sure.
Sort of picking one modal, of the options for one of the category groups, picking another one for another one, and not knowing exactly how they mix. I would like to get to that, but if we just start with each one in succession, and we start with regression, if we could.
Yep.
So with the regression, there's no doubt everybody agrees that the regression was relied on to some extent, and particularly with respect to public television, I think is
Yes.
where the board relied on it to the most expressly. So then if on the regression table, the one at 511 at least, which seems like a relevant one, if not the most relevant one, there is a 55% confidence interval to which the board takes note. And I guess my question is, I don't think you dispute that at some point a confidence interval gets so low that it wouldn't make sense to even take note of it, whatever take note of it means. That has to be true, I would think, right?
Yes.
So if it's a 10% confidence interval, it wouldn't make any sense to rely on it. So if it's 55, and I don't reject the premise that what the board is supposed to be doing doesn't have to meet the level of what statisticians said should be done to decide which clinical trial to give effect to if you're in the FDA or something. I understand that. But 55 just does seem like a pretty low confidence interval relative to what one normally sees, including even in this context and in previous iterations. And so I'm just wondering, what do you understand the board to have done with the 55% confidence interval, and why do you think that was okay?
Sure. So 2 points. I think it's helpful if I could to just explain sort of in ordinary English what a regression model considers. It shows the correlation between how many minutes a given kind of programming a CSO had and how much of their budget they were willing to spend on distant retransmissions. And so the inference is that the regression will show that if there is that relationship, if a CSO spends more of its budget and retransmits more of one category of programming, it values that category of programming relatively more. And so a confidence interval speaks to the strength of the correlation that the regression can establish. And there's no dispute here that the number of joint sports claimants minutes that were available for retransmission from 2015 on fell off a cliff. This is in part why the judges decided to adopt the Tyler model that had the above minimum fee only data, because Dr. Tyler himself said that that was the data that showed with, quote, the highest degree of confidence, and here I'm at JA 549, that there was an inference that was relevant to willingness to pay, and relative market value is the standard. So the confidence interval in and of itself, number one, does not sort of impugn the reliability of regression as an approach. And two, the judges candidly acknowledged that this model was not perfect, and that was, accounted for in the allocation that the judges ultimately awarded, which for the joint sports claimants was much closer to the poll that sort of would have been suggested by the survey than the regression. And I'd like to illustrate that if I could. The joint sports claimants, if the judges had allocated purely based on the above minimum fee operator Tyler regression model, the joint sports claimants would have received 2.3% in 2015, to 1.56% in 2016, and 0.61% of the fund in 2017.
Wait, hold on just one second. I just want to make sure. There's so many numbers. I just want to make sure I have the right chart in front of me. Do you have that somewhere that you can point me to, or?
So that's in the government's brief. And I just want to illustrate that the point is the regression model suggested, not surprisingly, that as sports were a category for which very few minutes of content were available for retransmission, that if one were to rely on that model alone, sort of as a comprehensive view of the industry, that the allocations to the joint sports claimants would be very low. But of course, what the joint sports claimants actually received was significantly more than that. The joint sports claimants.
Where are you looking?
So I'm looking at the government's brief at page 30.
Okay.
The joint sports claimants for 2015 received not 2.3%, but 11.42%. For 2016, not 1.56%, but instead 10.72%. For 2017, not 0.61%, but instead 12.36%. And this is because, as the judges acknowledged, there is just a more limited ability for a regression model because of how it functions and the volume of data that is input to it to explain joint sports claimants programming when the number of minutes is so diminished. And this is why they overweighted the survey evidence when it came to the joint sports claimants, not only because of the volume of data that was available to the regression, but because the judges expressly acknowledged that for some categories of programming, like devotional programming or like sports programming, 1 minute does not necessarily capture how subjectively valuable that kind of programming is for the consumer who receives
So
it.
I take just stepping back for a second.
Sure.
I think I understand that the point you're making, which is that, look, if you compare the regression results on one hand and the survey results on one hand, and the sports claimants are saying, just discount the regression, like use the survey. That's what we really like. They actually got something pretty close to the survey. What the survey, I take that point, but I understand what they're saying is, but the regression still mattered for public television. And then if the regression is fundamentally flawed and you took it out, then we'd actually have gotten even more than we got, because if you only use the survey, even for public television, then public television's share would have gone down some and our share would have gone up some more. And you should have only used the survey. You should have discounted this regression altogether, because the regression is fundamentally flawed. It's just not even remotely reliable. So yeah, we got pretty close to where you'd be for ourselves if you just did the survey. But you let the regression seep back in with respect to public television, which in a zero-sum game redounds to our detriment. I take it that that's what they'd be saying. So and I don't think you probably dispute that it makes some difference to them whether the regression seeps in at all.
Yes, of course. But as the judges explained, neither a regression model nor a survey model alone was the right or a reasonable even way to think about the entire industry as a whole. There are very different kinds of content that are involved here that are being retransmitted for some for quite a number of minutes, some for not many at all. And so the judge's task in determining what the relative marketplace value is, which is their task, which Congress left, entirely to their discretion to decide. The question is willingness to pay. And when for some categories of content, the number of minutes is illustrative, and for other categories of content, the number of sheer minutes is not as illustrative, it's perfectly reasonable for the judges under these circumstances to make the very careful and painstaking decisions that they did.
So I guess my question is, though, I think I have great sympathy for the copyright judges. I mean, and it's an unenviable task. And I'll just accept your premise that there's no perfect solution here. And there clearly were flaws. Everybody thought there were flaws, at least in some measure, to a lot of things across the board. But there's no doubt that the regression played a role.
Yes.
And if it's true, suppose that it was a regression that rested on a coin flip. I mean, even if it played a role, and even if the sports claimants got pretty close to where they would have gotten otherwise, nobody could sanction the use of a regression that has embedded within it a coin flip, because that's the definition of arbitrariness. And so I guess the question is, if the regression did play some role, even if I know that in a kind of a rough justice conclusion sense, you could say, look, this is not unrough injustice, because got pretty close to where the surveys, which is what you, the joint sports claimants, really are drawing attention to, would get you to. I take that point. But if the regression played a role and there's just a fundamental flaw in the regression, and I'm curious as to why, I want to give you the chance to explain why that's not the case, then I think we would still say, yeah, the regression played some role. It actually didn't inure to your detriment all that much, because you got pretty close to where you are. This is a huge approximation. This is a very unenviable task that the copyright judges have. they got pretty close. I get the instinct to leave it alone, but if it has an element to it that is just resting on something that's just fundamentally flawed, then we have to at least take a look at that. And so on that, could you just help me with the regression and just tell me why is a 55%, just two basic questions, which I think map onto their two basic questions. Why is a 55% confidence interval? Why is that okay to rely on it in some measure, which it looks like it was relied on in some measure. I don't exactly understand exactly how, but relied on in some measure. And then why is it okay that the regression spit out negative numbers, and that's a regression that we can still rely on in some way if it has negative numbers in it for sports?
I mean, big picture, because all of the economists who offered regression models in evidence testified that the fact that there was a particular confidence interval does not sort of make the reasonableness of relying on it in any part sort of stand or fall. The coin flip analogy is not quite correct.
Right. And why? Yeah.
Well, because, I mean, statistically, a 55% confidence interval is the likelihood that the result is not, for example, the number on the page, but it is instead zero, meaning that there is absolutely no relationship, no mathematically significant relationship between the number of minutes of different types of content that are retransmitted and the amount of royalties as a percentage of their overall budget that cable operators spend. If the confidence
By the way,
intervals-
by coin flip, I wasn't meaning to talk about 50%. I was talking about coin flip, meaning I'm just going to do a coin flip to see if heads, this side wins, tails, this side wins. I'm saying that's the definition of arbitrary. I'm not sure that 50% actually is the definition of arbitrary in particular context. I was meaning heads and tails. So I wasn't trying to compare 50% to 55%. But I think there is 55% as a confidence interval is lower than what one typically sees, including in this very context in previous iterations.
And the judges acknowledge that candidly. By statute, one of the judges is required to be an economics expert. The current member of that panel who is the expert is David Strickler. And what the regression illustrates is the strength of the relationship between the number of minutes of a different kind of programming and how willing, what percentage of the overall budget a cable operator is willing to spend. And I mean, I suppose the judges could have, thrown the proverbial baby out with the bathwater as to either. There was a gap in the survey data. There's been this gap for decades. Joint Sports Claimants commissioned this survey. I don't know why they didn't have it done differently, but that was the choice that they made. And I want to just make sure that I'm not suggesting that it's the pure numbers here that make the judge's rationale okay. I am not saying,
Right.
Hey, maybe they would have gotten a lot less, but instead they got more, and so it's all fine. We don't do that. We understand the court's decision in the settling the devotional claimants case. But I mean, the rough splitting of a difference, as the court said in Johnson, between two fairly but not wholly satisfactory outcomes is a familiar, permissible technique. And of course, it is a zero-sum pool. Every decision that is made with respect to one party affects another. This is in part why the structure of these proceedings is that the parties are incentivized to provide the proposals that most support an award to their group that is larger compared to others. It's not a flaw in the analysis. It's the judge's reality in terms of the evidence that was provided to them. And with respect to the joint sports claimants specifically, it is precisely because there was not a, more than necessarily 90 or 95% level of confidence about the strength of the correlation between the number of minutes and the willingness to pay, that the judges overweighted the survey evidence in response. I do also want...
I'm trying to figure out how far do we go into the merits of any of the methodologies as well, because there's a lot of case law that suggests that we should defer. These are experts. We're not the statisticians. That's not quite our role. And of course, we have to look at whether or not it's been adequately explained. But I just want to know, what's your thought on how far we actually look into, all of this modeling?
Yeah, I mean, I think the Johnson case is instructive. The standard of review here by statute is the APA standard of reasonableness. And so we do not ask whether this panel would have reached a different conclusion if it had been presented with the same facts in the first instance. We ask, given what was in the record, how did the judges approach the problem? Did they act in a way that was consistent with their prior precedents? Did they explain the choices that they made? Whether or not they were, perfect or not. The record here and the determination are what we look at, and we look at how those match up. And I think, as Judge Rogers, perhaps you said, I think it's fair to say that for every part of the record to which the parties are raising an objection, there is a corresponding part of the determination that explains why the judges reached the conclusion that they did. Nobody was going to be happy. The proposals in this case asked for the judges, all told, to allocate 150% of the money that was actually available. And so there are inevitably winners and losers in these cases. And these cases only come to the copyright royalty judges because the parties themselves cannot agree on what an appropriate distribution should be. But that does not mean that the judges are required to attain mathematical exactitude. As this court has observed, that is nigh impossible in these circumstances.
I don't disagree with a single thing you just said, and maybe I'm just not asking the question correctly, or maybe the question's just off, but if I could just try one more time. So on the table on JA 511.
Yep.
So suppose the left-hand most column was a 10% confidence interval. Suppose it was 10%. And then it said the exact same thing on the page. The judges take note of the 10% confidence level because, and would that be okay?
I think it, and I'm not trying to fight the hypo, but I think it really does depend on what else is in the record.
And why is that? So
because the judges are bound to make a decision based on the evidence that the parties put in front of them. And so if what is in the record is information that supports a 10% confidence interval, it's there because the parties have asked the judges to take a look at it. It's there because somebody has said to the judges, we want X share of the pie. And we think that this math with this confidence interval supports our proposal. And the judges say, well, we are trying to figure out what relative marketplace value would be, how these different categories of content would sort of offset each other in a market that has never existed, that is entirely hypothetical, and that the judges can only take what is before them.
So if the argument is, and I take the point that, somebody put this in, so somebody thought it was relevant, it's before us, we can give effect to it. I mean, I think one of the arguments that's being made is actually what this is about is the Tyler sensitivity analysis, and nobody actually thought that should be relied on. The sensitivity analysis, it seems like people are comfortable with the nonsense, if that's the right term, the non-sensitivity Tyler approach, the baseline one. But once you factor in the sensitivity one, that's not actually something that anybody was putting forward. So even though it's in there.
Well, I mean, and I want to address this point head on because it also gets to a point that the joint sports claimants have made about whether they proposed adjustment to and sort of how the judges treated that. Dr. Tyler testified that the form of the model that gave sort of him the highest confidence that the data that it analyzed reflected willingness to pay was the above minimum fee operator data. And of course, in the 3 adjustments that the judges made to this model, there were adjustments that accounted for the fact that in some circumstances, the minimum fee operator data could shed light on willingness to pay. The judges made that adjustment with respect to the Canadian Claimants Group. They made that adjustment with respect to PTV. And so the notion that a party can sort of propose something in evidence and then disallow the judges from considering it is nowhere to be found in the entirely discretionary standard that Congress has set in determining relative marketplace value. And it's the same reason why it's really not correct to say that the joint sports claimants proposed adjustment to, but that the judges ignored that. I point the court to footnote 221 of the determination and also invite the court to compare the proposal from 612 to 614 of the sealed joint appendix. This is the joint sports claimant's proposed finding of fact and conclusion of law. They set out there what the results would be for adjustment 1 and their adjustment 2 to the survey. And then at SJA 617, where they actually make a request for the figures they want, they reproduce the figures from adjustment 1, not from adjustment 2. So the judge's task here is to determine reasonable marketplace value based on the evidence in the record. And that is what they did. None of it was perfect. They didn't ignore the fact that none of it was perfect. They quite forthrightly acknowledged it. And that is all that, either the Copyright Act or the APA require. I want to briefly address, if I could, a couple of the other specific points that the parties were made in response to some of the honor's questions. I see that my time has expired.
I'm pretty sure my colleagues would too, but I still have some more questions.
Okay. So on the World Series question, I point the court to paragraph 71 at page 130 of the sealed joint appendix. This is where this is the page the JSC quote in their brief, and this is where they actually provide the number of subscribers that they believe meet the category of, it's section 111 or nothing if they want to watch the World Series. According to the joint sports claimants, that's between 70,000 and 94,000 subscribers, which I understand amounts to 0.13%, maybe as much as 0.16% of the overall subscriber pool. So this is not a circumstance where the judges ignored the significance of sports programming. It's a point that they agreed with. They would not have overweighted the survey had they not. As far as the point about how the figures could end up in the final allocation being below what the joint sports claimants characterize as a range of reasonableness, Your Honor, you were exactly correct. What happened was the judges individually for each category considered where in a range of rates would be appropriate for an allocation to fall. And that's based on how well a regression versus a survey sort of spoke to the kind of content that program category involved. That's not an inherently zero-sum analysis, right? I mean, the fact that the survey describes sports claimants content relatively better than it might describe PTV content is not, that's a qualitative conclusion, not a quantitative one. And so the judges conducted that assessment individually for each of these 6 claimant groups that participated in this proceeding. And the total was virtually 100%, but it was not exactly 100%. And so to allocate the funds that they had, the judges adjusted the numbers proportionally to reach an even total of 100. It's not as if the judges considered one range reasonable sort of right up until the final second and then decided inexplicably to assign a different number.
So can I just ask about that?
Yeah.
Just to make sure I think I follow how the final assessment was made. So let's imagine a world in which there's only 2 categories of claimants. Mm-hmm. And there's 2 ways in which we could decide what the allocation is going to be. Kind of like this, you have a survey one and you have a regression one, and then you only have 2 categories of claimants. Is this what happened? So the board would say, okay, for category of claimant A, the joint sports claimants, let's just say, the one mode that we think is better is the survey one. And the survey one for them gets them 55. And then for the second category of claimants, public TV, we think the better approach actually is the regression. And the regression one gets them 65. Mm-hmm. Okay, so then you put them in a hopper and you see 65 plus 55. Like I'm over 100.
Yes.
Okay, so I did 55 from one group, 65 from the other. Now I got to kind of normalize that.
Yes.
Get it within 100. I'll take the same ratio.
Yes.
And just taper it down to get to 100. So it's going to be a 5.5 to 6.5 ratio, but I'm going to get it within 100.
Exactly.
Is
correct.
That roughly what happened here?
That is exactly what happened here.
So my question is, that's interesting. And it's not what normally envisions, though. What one normally envisions is we'll figure out which one of these approaches just does the best job as a general matter. And then, yeah, we might have to make some adjustments to that approach. But rather than kind of picking one from one approach and picking one from another in a way in which, they could add up to 200. It could be you have 100 to 0 on one, 0 to 100 on the other one. We'll take 100 from here. We'll take 100 from here. put them both together, it gets to 200. We normalize it, each gets 50. I mean, you could do that, and I'm not sure it's arbitrary, but it does strike me as different to allow for an approach in which you're taking one from one column, taking one from another column, and then just kind of jamming them together. If I'm understanding the way this might have happened, although maybe I've got it wrong.
Sure. So first of all, a basic point. It is uncontroversial for the judges to make adjustments to models that the parties have proposed.
To individual
And
models, no question. Yeah.
Exactly, because at the sort of model level, the question is, what kind of glasses are you putting on to look at the entire industry? And for the 2014 portion of this proceeding, that question was not as difficult. But when it came to 2015, and all of a sudden we have 90% of the cable system operators paying only the minimum fee. We have regression models that indicate sort of levels of confidence of correlation between the number of minutes and the value of the programming that are wide, as Your Honor aptly pointed out. And on the other hand, we have a survey that systemically excludes portions of the market that choose to retransmit only one kind of content category. And neither one of those is sports, of course. It excludes the cable system operators that retransmit only PTV or Canadian Claimants Group content. I mean, I suppose the judges could have said, hey, you know, for each one of you, the regression would say this and the survey would say that, and we're going to put it together and average them. I mean, Johnson, this court's decision in Johnson would say that that was perfectly fine. Yeah. But because of the sort of the record that they confronted in this case, the judges, I think to their credit, took even more pains to consider both how well a lens of looking at the industry worked across the board and how descriptive it was for the type of content that each program group provided. And in that, again, the judges agree with the joint sports claimants. That's clear. It is apparent that for niche programming, simply saying, well, 1 minute is 1 minute is 1 minute is not a reasonable way to go about it. And so they didn't. I don't mean, again, to fight the hypothetical that there might be some point at which it's just, you know, it just absolutely makes no sense on its face. And there could be said to be no application of expert economic judgment or expertise to the decision. But I would submit that we are quite far from that.
But are we understanding it correctly then that there's two sets of numbers that they could have chosen from in the main, a survey set and a regression set? And then for different claimant groups, they started with a different baseline.
So
some of them, they started with the regression. For some of them, they started with the survey, and both of those had embedded with them adjustments. But as I understand what they said on J537 and then at 561 and 562, they went, well, and I take your point that doing it by claimant group makes a lot of sense because you've got to take note of the particularities that affect an individual claimant group. But for each claimant group, they figured out, actually the regression makes more sense for you. For a different claimant group, it might be that the survey makes more sense for you. So we're dispositively got to use that one for the particular claimant group, right?
right. I mean, the judges explained that they gave different weights to different models. This is not a case, though, of the judges sort of being bound to pick either the lower bound of one model or the upper bound of another model and justify sort of with precision every 1/10 of a percentage in between. I mean, for each claimant, the range is 0 to 100% of the royalties that were collected during this period. And so I want to agree with Your Honor's characterization, but I need to push back against the idea that there is a sort of a boundary that is imposed by one piece of evidence versus another, because it's reasonableness on the record as a whole. And here we had a record that supported wildly different outcomes. And the judges grappled with both the industry-wide view and how well each lens sort of mapped onto this hypothetical counterfactual marketplace that has never existed. And then for each kind of copyright holder who was claiming a share of that money, well, okay, there are some points to be made about whether this lens captures your content as well as it captures another group's content. And the judges weighed the evidence in the way that they explained, and explained their conclusions ad nauseum. And it's
But one thing they didn't explain is how exactly they got to the final figures. So, because they said things on JA 537 along the lines of, we heavily rely on the survey. But then if you look at the survey for a particular category, for a claimant category, it's actually the allocation doesn't map on to what the survey would have given you. It's adjusted in some way, and it could be adjusted more for some claimants groups than for others. And we don't have a through line explanation of how the judges got from the amount for either the regression or the survey to the final allocation for each claimant group.
so I think that perhaps our disagreement is whether the through line has enough math in it.
Or detail, just to
or detail
understand
to explain it. And I mean, here I have to point back to this court's decision in Johnson and in the settling devotional claimants. It is not sort of the sine qua non of reasonableness that the judges say, well, for you, we think, maybe the regression model, 71% explained well how your content, should be valued in a hypothetical counterfactual free marketplace that has never existed. I think if you just look at the figures, I mean, the judges are very clear about where the adjusted models, both regression and survey, come out in terms of the percentages, like the allocation percentages that they support. And for CTV, as my colleague acknowledged, the judges said, well, we think it's about regression and survey do about equally well in describing this kind of content. And so we're going to weigh them equally, and they come up with an ultimate allocation that's about in the middle. I don't think that it's the judge's obligation to say, well, for you, we think that, a regression model explains only 8% of the potential hypothetical counterfactual value of your content, and then have a whole nother round of dickering about whether it should be 8% or 8.1% or 8.2%. This touchstone is reasonableness. The parties, I understand, disagree about where the poles of reasonableness should be and whether there is any sort of distance in between them that the judges can consider, or whether they have to take one or another.
The presumption has to be, in your analysis, that the judges acted reasonably. And even though the range was extensive, whatever it shows was reasonable. I mean, your discussion is, they went to the middle, but suppose, if you knew what factors they applied, you'd say, well, it really ought to be closer to 5% or 90%, not, 55% or 52% or whatever it is. And all I'm responding to is it's a very different type of APA review than we normally do. I mean, the thought is that judges are not experts, but we have to understand what's going on. And I mean, the briefs do a great job in one sense, but the appellants raise a lot of questions. And your response basically is, if we're just applying a substantial evidence reasonable test, the judges did enough. They took what was given to them and decided whether that evidence was persuasive to them in terms of what they had to do.
Yes, that's exactly
that's
correct.
The end of our review.
Yes, Your Honor.
So if they hadn't addressed a whole area of argument, that would be arbitrary and capricious. But they addressed everything.
Yes, Your Honor, and indeed.
And so unless, you heard counsel, appellants here. they take very strong positions on there's no way the court could adopt your position. Because just factually, and I think that's what I understand the Chief Judge's questions to be exploring is we understand the words, but do we see the analysis that explains those words? And sometimes I do, and sometimes I don't. And I realize the board has, a terribly burdensome task here, and it's limited, as you point out. So long as it's somewhere around what people were asking for, claimants, that's good enough in this context.
So, Your Honor, I think it would be, and I think that the copyright royalty judges did much more than that here. I think the core of what we are sort of going back and forth about is when the judges say, we weight the survey evidence more heavily for one claimant versus another. Do they need to define with a number what that means in order for the decision to be reasonable?
Or why?
Well, why they do explain. They explain that the survey evidence is more persuasive for the joint sports claimants compared to the regression evidence, and they try to account for that.
Yeah.
Mathematical exactitude, again, this court has recognized is impossible, and I am unfamiliar with any case in which this court has ever said that reasonableness requires saying, well, if you think it's more heavily weighted than another, we have to hear you say that it's 71% instead of 50%. It might be a different story if the judges had said, well, we think the survey evidence is much more persuasive for the joint sports claimants, and so we're going to weight it more heavily. And then the ultimate allocation was the regression model number. But we don't have that incongruity here, because what the judges are trying to do is pick a number that is reasonable for each party, sort of under both their individual circumstances based on the kind of content they have and based on what they know about how this market does and hypothetically could work as a whole.
So here's one concrete example that I think is in the briefing, and it may have been mentioned earlier, but so the judges said that for both CTV and for program suppliers, the survey results weighed heavily. I think they use the same locution for both. And then if we look at 2015 to 2017, which I think is the relevant years for this, maybe they also did it for 2014, but I'm going to disregard that for now. So for 2015 and 2017, the survey allocations for CTV, just look at 2015, for example, the survey allocation for CTV was 19.2, and the allocation for the judges was 19.78.
Yep.
Very close. Okay, so that not only heavily relied, but maybe really heavily relied. That makes sense. But then if you look at program suppliers, the survey allocation was 18.4, and the judges' allocation was 28.29. So that's not to say that they didn't heavily rely on it, but it's quite a bit different from where CTV wound up. And it kind of turns out to be in the middle of the survey versus the regression, because the regression would have been 44.8, the survey would have been 18.4, 28.29 is closer to the survey than the regression, but it's, in the middle. And that may be fine, but we just don't know, because what we have is an indication that there's heavy reliance on the survey for both, to different degrees, apparently, to pretty significantly different degrees, because one of them's almost towing it exclusively to the survey. The other one's pretty far from the survey, not all the way over to the regression, but kind of in the middle. And that's what we have to go on. So we don't know exactly how it was weighed. We know there was weight given to it. Does that seem fine?
Yes, because what the APA requires is not the mathematical precision, and I'm sorry to keep returning to that phrase, that the kind of inquiry that you propose would entail. If the ultimate number was completely inconsistent with the reason that the judges gave for arriving at it or for trending in that direction, it would be a very different case.
So do you think it would be inconsistent if the number was directly, if the statement was made, we heavily rely on the survey, and then the number turns out to be exactly in the middle of the survey and the regression?
No, because the final number, recall, accounts both for how well the survey and regression evidence describes the particular kind of content in that category, but how it maps onto the other 5 categories that are also at issue. And so it's too simplistic to say, well, there was this number and there was this number, and, they had to pick either something in between and they had to say it was 50-50. And then if they were above this number, then that means it was unreasonable. I mean, that is just not
I think I agree. I believe I understand this and agree with you that because it's a zero-sum game, even if you rely heavily on one,
yes,
even if you rely exclusively on one, it's not going to wind up being that exact one because it's going to be adjusted. It's going to be adjusted based on what happens elsewhere. I guess what puzzles me some is that might be true, but then with one where you heavily rely, it ends up basically at exactly the same place. With another one in which you heavily rely, it ends up quite a bit different. I think there would be adjustments, but I would imagine that the adjustments would occur in a somewhat equivalent or proportional way such that you would see some predictable result. And I guess my question is, it doesn't turn out to be that way as between CTV and PS, for example, for 2015.
I understand that. And that is a product of the reality that there are vastly different kinds of content that are all lumped in together under the Section 111 license. I mean, the Section 111 license is about retransmitting content. It's about sending it beyond its local service area, not about what somebody sees when they turn on the channel. And so the fact that, as I may have tried to express earlier, that the joint sports claimants type of content is better described or more reasonably described by survey data. I mean, it's true that because we've got to add it up to 100 and we don't have unlimited money, that there's a sense in which it's zero sum, but it is truly a qualitative analysis. And the fact that the survey evidence might weigh more heavily for one group does not mean, as a matter of what is reasonable or what the evidence supports, that the survey evidence must, as a result, be deemed to weigh less heavily for another. And look, if the judges, acted in a sort of excess of earnestness and trying to go beyond the idea of, what would be sort of the copy and paste model that we could apply here and what would that spit out? I mean, they certainly could have, but what the judges did in this determination was agree with, in the main, the parties' arguments that they're making here today. I understand that the parties are saying, well, not only was that a good argument, it was a really, really, really good argument. And so, my number should have been bigger instead of smaller. That's not the sort of decision that this court superintends. And it's not the kind of, question that is susceptible to the task that the judges have before them, which is to determine relative marketplace value, allocate, a finite sum of money based on that, and do it in a way that is reasonable and supported by substantial evidence in the record.
I'm sorry to belabor this. I have one more question, just one more question
Sure.
about the kind of picking from one category and picking from the other. I can understand the appeal of saying this category is more, this type of analysis is more explanatory for joint sports claimants. This type of analysis is more explanatory for public television. And so I understand the appeal of doing that. I guess my question is this: if we imagine the world in which there's only 2 categories and there's only 2 types of analysis, so the 2 categories are joint sports and public television, the 2 types of analysis are regression and survey. If the board says for the sports claimants, survey makes more sense, for public television, regression makes more sense. So that's what we're going to do. By definition, aren't you saying, if you say for public television, regression makes more sense, and you use that number, aren't you necessarily then, by using that number, also using the regression number for the joint sports claimants too? Because if you bring in the 65 from there, you're necessarily bringing in the 35 for sports claimants too, because the 65 is just 100 minus the 35. So the 35 just necessarily gets baked in. And then, it's the same is true with the converse too. So picking one from here and picking one from there, I get it.
Yeah.
But it seems like you're necessarily also picking the other one too. So what have you really gained by doing that?
Well, first of all, we don't dispute that all of this, because we're in a zero-sum world where the question is which dollars go where. that every decision with respect to one party has some effect on another. I would suggest that it's different from saying that on the one hand, we think the best model for the PTV is the regression model. And on the other hand, there's something sort of disingenuous about us saying that we think the survey model is the best model.
I don't think it's disingenuous. I just wonder what the ultimate effect of it is. Yeah.
The effect is that there is an effect. Nobody disputes this. And the money has to be divided up. And the judges, including the statutorily required economic expert, looked at the evidence that was in front of them and made a reasonable decision, which they supported by substantial evidence and which they explained thoroughly. That is what the Copyright Act and what the APA requires. And as for the points about, if you don't mind me picking up just a couple of points that the other side made, the minimum fee station data and the must carry data, I'm happy to address that. But to Judge Rogers' point, we are not sort of zooming into the weeds level of what the judges did in these circumstances. They had the evidence they had. They made the best of it that they could. They explained their choices. And that is sufficient to affirm.
The end of it, in your view.
Yes.
And so our questions about the factors they took into account is just not part of this review.
I don't know if I agree with that because, if the explanation and the outcome was sort of black and white or seemed like completely irreconcilable, I think you might say that the explanation was not sufficient.
Point about, in one instance it's very close, in another instance it's quite a difference. And yet we look, you say, at both in the same way.
This is the scheme that Congress established, and it encompasses many different kinds of content in a marketplace where, as the judges observed, the sort of strongest factor in a cable system's actual decision-making is inertia. We're not dealing with an industry where on the demand side, we have a copyright consumer that is sort of parsing this, different content very carefully. It is a difficult task. It is a square peg in a round hole in a triangular tube. It is a really challenging exercise, inevitably, because of the way that the statute operates. But the fact that the evidence was flawed, the judges acknowledged it. The judges accounted for that. They reached conclusions as far as the final numbers that they explained and that are reasonable. And that is the end of the analysis. We ask this determination be affirmed.
Thank you, counsel.
Yeah.
We'll hear from interveners counsel now. Inertia may or may not explain why some unnamed homeowners might still have a DirecTV satellite dish in their backyard, but.
May it please the court, I'm Matthew McLean from the law firm Pillsbury, Winthrop, Shaw, Pittman. I represent the settling devotional claimants, but today I'm speaking on behalf of all four of the joint interveners, the SDC, the Canadian Claimants Group, the commercial television group, and the program suppliers. And I would say that during the 5 weeks of hearings involving 6 parties, 33 live witnesses, hundreds of exhibits, these very complex econometric models that we're talking about, survey data, the numerous industry professionals that testified, the four of us joint interveners disagreed on plenty. But today we do come here agreeing on 2 things. First of all, is that in the face of this very extensive, very complicated record, the board came to a reasoned decision supported by substantial evidence. And the other thing is this. Some of these funds at this point, we're talking about as far back as 2014, some of these funds were deposited more than 10 years ago. And as this court has recognized, royalty distribution can never be an exact science. Rough justice is bound to prevail. In this court's words, perfection in dividing up this royalty pool, much less consensus, is simply not going to be attainable. Now, many of the same issues that we're debating right here today and many other new issues are now before the board again in the next round of proceedings, as they have been in prior rounds of proceedings. And that's as it should be. And in fact, this court has expressly contemplated as a reason against adopting an overly inflexible approach in reviewing the Copyright Royalty Board's decisions, as this court contemplated in the 1998 NAB decision. In the annual determination process, the claimants would be able to improve upon the quality and the sophistication of their evidentiary submissions. So that in the prior round, in this proceeding from the prior round, the parties have improved upon, sharpened their arguments, brought in new arguments, brought in changes to the marketplace. And the next round, we're going to do the same thing. And we're going to incrementally get, hopefully, better at measuring this amount. But the standard that this court applies to what the judges are doing is a deferential standard. It's a standard that asks, did the judges come within a zone of reasonableness? And that word zone it has a meaning here. I mean, and the ends of that zone are not necessarily going to be well defined. But at the end of the day, Congress intended and Congress directed that these decisions were going to be made by judges, not by econometricians, which means that they're going to be able to look at these econometric approaches, these survey data, all of these kinds of data points, consider them as reference points, but then at the end of the day, they have to make a judgment call, which inherently involves weighing different evidence. So I definitely want to get into the quantitative evidence, because that's mainly what the petitioners are bringing up. But in doing that, I would ask the court to bear in mind and to look at it through the lens of two things. But first of all, that the standard that the judges were applying is one of relative marketplace value, not absolute value. And none of these quantitative techniques were intended to measure in absolute terms. We're talking about the proportion of value, one category against another. And so in balancing those, you have to take that into account. The second is, and this is very, very important, is don't discount the qualitative industry-based evidence. The industry experts, from cable system operators, from television stations, an appraiser of media assets, these quantitative approaches were reference points. And that's a word that the judges have used, that this court has used. The quantitative points provide reference points, but nowhere close to the whole picture. At the end of the day, there is a judgment call that has to be made, and it's not necessarily going to be directed by X percent times X percent is Y. That's why the zone of reasonableness is the standard that this court has applied. So going to these quantitative approaches, and there are a couple of points I want to make quickly. First of all, today the petitioners are taking some pretty hardline positions. Okay. In the court below, they were much softer on some of these same issues. Okay. JSC's counsel today cited Dr. Rubenfeld. He was our expert witness, not theirs. Their own expert witness acknowledged that the above minimum fee data in a regression analysis or data from systems above minimum fees can be informative and were informative in prior proceedings. They disagree that they were as informative in this proceeding, and the judges took that into account and accordingly gave less weight to the regression analysis than they did in the prior proceeding. TTV, similarly, public television's own expert witness, their own expert econometrician, present an alternative analysis on above minimum fee data only. It is not the case that the judges gave zero value to PTV minutes in below minimum fee systems. The judges weighed all the regression approaches that were presented, including those that included minimum fee systems. They relied primarily on the regression on above minimum fee systems, and then they identified the direction and approximate magnitude of potential biases. And they did the exact same thing with respect to the Bortz surveys. They identified a known bias, a bias that JSC itself, that joint sports claimants themselves admit that all parties agreed existed in the surveys. They considered multiple different methods of performing that adjustment, and they chose a method and they explained the choice that they made. They did this with both of those two techniques. And then Chief Judge Srinivasan, as you said, they then made choices. Are we going to be closer, not necessarily exact, but closer to one or the other? And then, of course, they had to normalize that to equal 100%, which means you're not going to get exact percentages. And they explained in rough terms the direction and the magnitude of the changes that they were making. And that it may seem like an unusual way of doing things, but it is exactly the way it was done in the last proceeding. The program suppliers, this court's decision, the program suppliers proceeding in 2020, they did the exact same thing. They relied on survey regression expertise. They explained why some categories they used one more than the others, and then they normalized it to 100%. They did essentially the same thing in the 1998 NAB decision, which this court also affirmed. So this is essentially the same technique that has been affirmed in multiple decisions of this court. I see that I'm out of time, but of course I'm happy to answer any of your questions.
Thank you, counsel. Thank you.
We request the court to affirm. Thank you.
Thank you. Theodore, we'll give you 3 minutes for rebuttal. Both sides will give 3 minutes for rebuttal. And of course, if we have questions, we'll be on that.
Okay. Thank you, Your Honor. So I want to emphasize that the regression is wrong for everyone, not just sports. And one point I didn't make before is that if the regression calculates that so CTV's relative percentage of subscriber minutes is cut in half between 2014 and 2015. That's at JA 248. But its allocation under the regression stays the same. Devotional percentage goes down between 2014 and 2015, but its allocation under the regression goes up. Program suppliers stays the same in terms of minutes, percentage minutes, but its allocation goes up by 1/3. And again, that's the chart with minutes is at JA 248. The regression calculates that the value of a minute of sports is 30% less in 2015 than in 2014. And you see that if you go to the JA 241, the coefficients for JSC for compensable minutes are 30% lower. And so all of this is showing that the regression is not calculating minutes at the per minute value for anybody. So let me turn to your question about the synthesis. So if you look at so what the government said on page 26 of its brief is that the board for 2014 was giving equal weight for JSC to Bort's survey and to the regression, and that's obviously not what the results showed. With respect to your specific question about JA 561, I took a look at that, and I think what's going on there, so if you actually look at the 2014 shares, they add up to 99.9 under the survey. That's the adjustment B. And then the survey adds up to 100. And so I think what's going on is that when the board does its completely unspecified combination of those two things, it somehow gets to over 100. And that's part of the problem. We don't know how they did it. But I'm not sure if this is making sense, but the reason why sports is below those two numbers is not some artifact of the fact that the survey and the regression add up to more than 100. It's an artifact of the fact that the board's totally unclear weighting adds up to more than 100. So that can't explain why JSC is below both of those things for 2014. I want to correct one thing the government said, which is that with respect to the 55%, Dr. Tyler did not propose reliance on 55%. If you look at the page where the board does 55%, they say it's derived from one of his charts. If you know the standard error, you can just derive any confidence interval you want based on some basic equations. There's absolutely no regression expert in this case who said that it was proper to rely on 55%. And we never got a chance to explain that it wasn't proper to rely on 55%.
You had a chance during rehearing.
I think we raised some things during the rehearing petition, but we weren't required to raise everything during the rehearing petition.
Yeah, but you
I'm
say
sorry?
you say you didn't have it. You didn't have a chance. You did. That's all I'm saying. Whether you chose to do it or not is another issue.
But we're raising it in this court,
I
and it's
understand
arbitrary.
that. I'm not going to belabor this.
I'm sorry, Your Honor.
But I would like to just follow up on that. I mean, if you knew about the reliance on the 55% as of the initial decision, right?
Yes.
Okay. So you could have made an argument as to the 55% on rehearing before the board.
What we said on rehearing before the board was that reliance on the above minimum fee was arbitrary for a variety of reasons. I don't recall if the 55% was in our rehearing petition or not, but we absolutely said that reliance on the above minimum fee Tyler regression was completely
No,
arbitrary.
we understand that.
Yeah.
And the board responded to the arguments that were presented on rehearing. That's my report.
So, and Your Honor, I think, let me talk also, the government said that Tyler said that the above minimum fee gave him the highest confidence. If you actually look at his testimony at JA 216, that's not what he says at all. What he says is that as to that 10% of people or of systems, he has the most confidence, but not that he has the most confidence that if you take that 10%, you can apply it to the entire
No,
thing.
he says that in two different places at least that I saw. So it's just the board saying, look, the expert hears the objection and he says he has confidence still. That's sort of the analysis as I understood what the board does.
So just a couple of very quick points. There was no response on our argument that it was arbitrary to apply McLaughlin adjustment to everyone but PTV, which is the only claimant it was designed to help. The only claimant it was designed to help, the board says it's arbitrary to apply it to them. And that requires remand if nothing else does. And with that, my final point is that with respect to our second adjustment, I think the government said we didn't propose it, but we did on SJA 614 and SJA 615. We proposed that adjustment. We said we preferred adjustment 1, but that alternatively adjustment 2 was a good adjustment as well.
But you preferred adjustment 1. That's what the government said.
We
Here,
did
today.
We did prefer adjustment 1, but we very explicitly said that adjustment 2 was an alternative.
Just as a preservation point, you're saying you at least.
Yeah.
Well, we said it. We said both were economically sound. We were proposing adjustment 1, but if the board rejected adjustment 1, adjustment 2 was certainly better than McLaughlin. That's what we said. And that certainly preserves it, Your Honor.
Thank you.
Thank you.
Mr. Dove, we'll give you also 3 minutes.
Thank you, Your Honor. Just wanted to focus briefly on, I think our main point at this, it was arbitrary and capricious to assign 0 value to all the programs on all of the cable systems that were paying the minimum fee. That was 90% of the retransmissions at issue. So this is not a weeds level situation. It's not a rough justice situation. This is a fundamental flaw that excludes massive quantities of programming. And it particularly impacts public television because the panel placed dispositive weight on the regression for public television. But if the board believes that the regression cannot measure value on minimum fee systems after the WGN conversion, then or if the board, if it believes that on remand, then the board would need to rely on the survey. It credited the survey for measuring the value of minimum fee systems. I mean, the survey measured that. And so adjusted by McLaughlin, that would get to the point where you just rely on that one piece of evidence for all the parties and you wouldn't have the cherry picking problem. The Tyler sensitivity was not endorsed by anyone as a measure of relative value. And I think that's important to keep in mind. Unlike the joint sports claimants, we are not just advocating for our preferred method. We're saying if there is some evidence, it's okay to adopt that. But there was no evidence that minimum fee systems should be accorded zero value, and that that quantity of minutes, that millions of minutes should have been excluded from the analysis. there was evidence of value from every single party for both minimum fee
so
systems.
You're taking issue with the board's statement that it couldn't be accurately measured, right? That's what we were going through in the record when you were first arguing.
I think in part, Your Honor, we're taking issue with that, but really we're taking issue with what they did with that. They said it couldn't be accurately measured, so they just decided to give it zero value, to totally zero out
But
all these minutes of
my
programming
point
to the,
is they gave a reason.
well, they gave a reason.
Your argument today, just let me be clear, because I may have misunderstood your argument. Your argument is that they didn't give any value. And the board said, well, it couldn't be accurately measured.
They still.
And is your argument that no, that's incorrect because there was expert testimony that the board?
Yes, well, yes, Your Honor.
Yeah.
All the evidence in the record suggests that it could be measured. And all the evidence in the record suggested that it was not zero.
So what did you think the board meant when it said could not accurately be measured?
I think they were frustrated with what we've been frustrated with here today, Your Honor, which it's very hard to pinpoint. You've got different methodologies coming at it differently. But the reality was that the evidence before them clearly measured it. The board survey surveyed minimum fee systems, and measurements were given as to the value of the programming on those systems. The regression analyses, all the parties, put forward a regression analysis. Their preferred models measured the value, had valuations of those minimum fee systems, and did not exclude, just throw them out of the analysis. So I think that they were just frustrated with the ability to get that precise figure. And
Okay.
conclude with
Thank
that.
you, counsel. Thank you to all
Thank you.
counsel. We'll take this case under submission.
It's honorable board that stands for action until Thursday, November 20th, 30 a.m.